Thank you all for coming to the Criminal Justice and Public Safety Committee this afternoon. On our agenda, we have a couple of public hearings and then a few work sessions. I'd like to start with LD 484, which is an act regarding the Department of Public Safety. This was a concept draft, and there has been language for this that was published recently. I believe everybody has the language, and with that, I will we will do introductions, and then I will open the work session, but we'll go down and start in the corner with Representative McIntyre.
Thank you, Mr. Chair. Matthew McIntyre, House District 18, Lowell, Burlington, Greenbush, Pasadum, Clifton, Amherst, Aurora, Osborne, Great Pond, Dedham, Eastbrook, Mariahville, Otis, Bennington, Du Bois, and Cherryfield.
Good afternoon, folks. My name is Representative Chad Perkins. I represent District 31.
Hello, everybody. My name is Mana Abdi, and I represent District 95, which is part of Lewiston.
Good afternoon. I'm Representative Bob Nutting. I represent the towns of Oakland, Smithfield, Mercer, Starks, and a portion of Sydney.
I'm Representative Tavis Hassenfuss, House Chair of this committee.
Hello, everybody. I'm Senator Chip Curry. I represent the 26 rural, coastal, and island communities of Waldo County.
Good afternoon, everyone. Nina Milliken, House District 16, Blue Hill, Brooksville, Castine, Sedgwick, Surrey, and Trenton.
Good afternoon. I'm Mike LaJoy. I represent District 96, which is part of Lewiston.
Good afternoon. I'm Steve Bunker, District 75, Farmington and Chesterville.
Good afternoon and welcome. My name is Donnie Ardell. I represent House District 6, which is a series of towns in central and southern Aroostook County.
Thank Mr. Representative Lookner. Have you?
Reason Lookner, representing House District 113, which is several neighborhoods in Portland.
Thank you. And with that, we'll go into the work session on LD 484. Sorry, public hearing on LD 484. And I believe we have a few people who would like to testify in favor of this bill. Director, would you like to come up?
Whoops.
Good afternoon, committee members, and thank you for the chance to appear before you today. I'm here, I'm Will O'Neill, as you know, the Director of Maine Emergency Medical Services, and I'm appearing before you today to testify in strong support of LD 484. Senator Beebe Center, Representative Hassenfuss, and honorable members of the Joint Standing Committee on Criminal Justice and Public Safety. This legislation proposes to clarify the authority for licensed EMS agencies within the state of Maine regarding controlled substances. Currently, emergency medical services and their professionals respond to emergencies in which a controlled substance is used to treat a life-threatening medical condition, such as a seizure. On February 5th, 2026, the U.S. Department of Justice Drug Enforcement Agency released its final rule implementing EMS agency registration under the 2017 Protecting Patient Access to Emergency Medications Act, with that rule effective March 9th of 2026. In response to this rule, Maine EMS supports this legislation as providing needed language that directly supports our system's provision of life-saving care. Worth noting, community paramedicine services and clinicians licensed by the board are included in this authorization, reflecting the evolving nature of our state's healthcare delivery model. As you well know, in our other efforts, we've emphasized the importance of having the right tools in our toolbox to resolve complex regulatory circumstances. LD 484 provides similar clarity for us. Thank you for your time today, and thank you for your continued support of Maine's EMS clinicians and the patients they serve. More than happy to participate in any work session regarding this bill and to answer any questions you may have.
Do we have any questions for the director? Senator Curry?
Can you explain a little further why this bill is needed?
We're acting very proactively. We responded quickly when we found out this rule, which was put in place in 2017, but was not finally promulgated until February. They gave us a registration seminar December. We started talking with the lead agent in charge for the New England region, and we've been back and forth regularly with them. We believe that Maine currently has the authority in statute and through to rule, to protocol, and then to the administration. However, we've provided those documents to the DEA. They've asked us for a summary of those documents, and then they've sent those documents to their legal team for review. And their effective date was the 9th. So we're here in front of you today to try and be proactive about any rulemaking authority that we might need down the road, but we actually think that we're going to be able to absorb this. But being proactive, if they make a decision different than what we anticipate, is going to be our best course of action. And again, until they finally promulgated the rule, we really didn't have a way to respond. It's my understanding that they have not answered any of the questions from the New England states that have provided documentation, and the registration process that they outlined as effective on the 9th is not open at this time. So we're working quickly to be sure that we're aligned and our agencies are aligned when they have this process ready.
Thank you very much.
Thank you, sir.
Representative Bluckner?
Thank you, Mr. Chair. Thank you, Mr. O'Neill. Can EMT professionals and EMS professionals administer any controlled substance with supervision or guidance from a medical professional?
The way that it's currently written in state laws, we work under standing order or protocol, so that an EMT and a paramedic out on an ambulance by themselves at a scene would not require a physician to be physically present. They have a standard set of guidelines to follow, and medications in schedules class 2, 3, and 4, which are covered under this act, are provided for in those protocols. This allows us to do any rulemaking that might come up based on the DEA's final decision.
Gotcha. All right.
I don't see any further questions, so thank you, Director, for bringing this issue to our attention so promptly.
Thank you, members.
Is there anybody else who would like to testify in favor of this legislation? Is there anybody else in the room who would like to testify in opposition to this legislation? Is there anybody in the room who would like to testify neither for nor against this legislation?
Representative Hassenfuss, Senator Beebe Center, and esteemed members of the Joint Committee on Criminal Justice and Public Safety. My name is Jason Cooney. I currently serve as a licensing agent and staff liaison to the Rules Subcommittee of Maine EMS within the Department of Public Safety. However, I am here today in my capacity as a paramedic with the state of Maine and as a private citizen. My testimony today is not representative of the opinions or position of Maine Emergency Medical Services, the Department of Public Safety, or the executive branch. I'm not receiving any compensation for this testimony. It was prepared on my own time without state resources, and I have taken a personal day to be here. I am here today testifying neither for nor against LD 484, an act regarding the Department of Public Safety as amended by its sponsor. I firmly believe that this legislation is rapidly needed by the EMS community in the state of Maine to ensure continued life-saving care for patients and must be emergency legislation. I've spent my entire life and career within the state of Maine. I was initially licensed in the state of Maine as an EMT while I was in high school. One of the first incidents I ever managed was a fellow classmate of mine during school who was seated next to me and who had a seizure. Luckily, this seizure was self-limiting and did not require medication intervention. However, I'm before you today because I could only imagine the horrors of the what ifs. What if it wasn't self-limited? What if it required an ambulance to respond with trained personnel who couldn't stop the seizure and get my classmate breathing because they couldn't have midazolam, a benzodiazepine classified as a Schedule IV controlled substance and currently part of Maine EMS's protocols for the treatment of a prolonged seizure. The use and storage of controlled substances by EMS have legally been a gray area for decades. EMS was not originally included within the Federal Controlled Substances Act of 1970, or CSA. In 2011, according to a CDC brief, the DEA asserted that the CSA did not allow for the dispensing of controlled substances under a standing order, and that the use of controlled substances could not occur outside the physical presence of a physician. These challenges led to the Protecting Patient Access to Emergency Medications Act of 2017, or the PPA-EMA. This federal legislation amended the Controlled Substances Act to allow DEA registration for EMS agencies and the use of controlled substances under standing orders by EMS clinicians working for a registered EMS agency. Like many other pieces of federal legislation, it required rulemaking by the DEA to implement. In 2020, the DEA released a proposed rule implementing the PPA-EMA for public comment. Without advance notice, the DEA published its final rule with some changes on February 5th, 2026, effective March 9th. Maine EMS's system has relied for decades on the goodwill of its local community hospitals, who have helped to provision, organize, record keep, and account for medications, including controlled substances. This relationship has had little benefit for these hospitals, who often supplied those medications at cost, other than the understanding that it was the only way for EMS agencies to receive those medications, placing those hospitals within the same legal gray areas EMS agencies operate in. Hospitals have to be mindful of DEA rules regarding distribution of controlled substances and are the responsible party if controlled substances go missing, are diverted, or stolen. Registration is not currently open to EMS agencies within the state of Maine because the DEA does not believe that Maine's laws currently authorize EMS agencies to procure, possess, furnish, or administer controlled substances, which is a required component for registration according to the DEA's rule. The legislation before you directly addresses that problem by explicitly authorizing those activities for the many components of the EMS system who will provide the level of service where controlled substances are necessary. This legislation also authorizes the board to engage in rulemaking. This accomplishes two goals. First, it allows the board to specifically address components currently in Maine EMS's rules related to drugs and medications, which includes controlled substances. Second, where there are many unknowns about this legislation, it allows the board to utilize its rulemaking to respond to any additional requirements that may be necessary to ensure our system continues its access to controlled substances. If the committee has any questions, I would be more than happy to answer as I am able. Thank you for your time and consideration.
Thank you, Mr. Cooney. Representative Lookner, do you have a question?
Thanks, Mr. Chair. So, thanks, Mr. Cooney. You're neither for nor against, you're very for the legislation. You just think it needs to be an emergency.
Exactly.
Go.
Senator Seaway?
Thank you, Mr. Chair. I was just wondering, on this, is there anything that you feel, I know he's going according to rulemaking. So is there something else that should be added to that piece just to make sure it happens the way it should work? I mean, I know you're going by rulemaking, but there might be something that's missing, you know?
I think it's hard to answer what's missing right now, where we just don't have certainty from the federal government on what the requirements are, if the requirements are, how the requirements are. All we have is the rule, not how they interpret it. I believe that those questions have been asked of them, but the answers haven't been given. There's a possibility that it may have to end up before you again, but the statutory adjournment date for the session, as you all well know, is April 15th. And this is an opportunity to get this before you. If we don't, we would be lapsed until next January.
Just to follow up, just wondering if there's a model state that uses it now.
So looking at the other states around us, Massachusetts has a separate controlled substances registration for all their healthcare, which ambulance services are included in. New Hampshire doesn't have this really addressed. Vermont operates currently under a medical director system, not a hospital-based system. So for them, they have a hub and spoke model where this registration will actually be a lot easier to implement because it consolidates where the DEA, where the physician had to have DEA registration at each individual service that they were the medical director for. Now the EMS agency has one registration and it's one location. New York, I don't believe has addressed this as of yet. Connecticut, I don't believe has addressed this as of yet. New Jersey, all of their ALS is hospital based, so they're already considered registered. And there's a lack of consensus across the board and across the nation on which parts mean what and how to address it. So I guess the best way of answering is there's not really a great model that we could draw from that would work for Maine EMS right now here today.
But probably Vermont is the one you like the best.
The challenge with that is that they've operated under that individual medical director system. And under these rules, that DEA registration would be the component anyways that they would move to. So I don't know if it's the best model, but in terms of comparables, they kind of get close to us, but not really, because we operate under the hospital's DEA registration currently, whereas they each service has their own medical director, a physician medical director, who currently needs to be registered at each station that service has that stores controlled substances, and that's a cumbersome administrative burden for those physicians.
So to the chair, is it possible we could have our analysts look at some models that might be something that we could look at?
Yeah, that's possible. We could talk about it on the work session.
Yeah.
Does the committee have any further questions? Thank you, Mr. Cooney. Just before you go, I really appreciate your paragraph that says the DEA does not believe that Maine's laws currently authorize EMS agencies to procure, possess, furnish, or administer controlled substances, which is a required component for registration according to DEA rules. In my reading of the language of the bill, is it that the bill expressly remedies that? And so the hope of that is trying to be accomplished here is that because it's ambiguous right now, if we pass this bill that very clearly says, yes, the state of Maine has authorized EMS to get, have, and give controlled substances, then the federal government, the DEA, will say, yes, that meets the requirements, or we'd be very surprised if they didn't say that meets the requirements. So that's the crux of this bill. Am I correct in that summary?
Yes. So if you turn your attention to the last page of my testimony and the last footnote, that's the text from the regulation that this bill is trying to directly address. And the key phrase is demonstrating it is authorized to conduct such activity under the laws of each state in which the agency practices. So that's where this bill is directly trying to address that.
Yeah, thank you. Thank you for that piece.
Mm-hmm.
I don't see any further questions, so thank you very much for your testimony. And I don't believe that there is anybody else in the room that is waiting to testify on this bill. I don't see anybody online. So with that, we'll close the public hearing on LD 484 and Representative Lookner.
Thank you, Mr. Chair. I was thinking we might go in a work session on this bill. I'll move that.
There's been a motion and a second to go into work session. All those in favor of going immediately into work session? Thank you, Will.
Next year.
So strong.
Okay. So we have LD 484, an act regarding the Department of Public Safety. As you're all probably aware, this was a placeholder from Representative Hasenfuss. So accordingly, if the committee is going to vote today, it's going to be, if you're in support of the bill, it's going to be ought to pass as amended regardless. There are a few technical issues that I think can easily be addressed in language review, just regarding some incorrect language regarding the controlled substances citation and some other language. But I think generally, I know to Senator Searway's point, there's discussions about what is the best path forward to take. We are on very limited time here, and this is a very open approach, allowing EMS flexibility in adopting these rules to make sure it complies with DEA. So that is an option, but we are in limited time here. And I understand from Mr. Cooney, there's also a suggestion of an emergency preamble, which given the situation might be appropriate as well. That's all the information I have. Like I said, there are a few things, but I think easily to address in language review, which we will, at this point in session, will probably be over email.
Representative Perkins?
Thank you, Mr. Chair. Considering, and I understand the senator's concerns, but considering that we're leaving this for rulemaking, I don't think this has to be addressed before we pass this. And so having said that, I'd like to make a motion to ought to pass as amended with a further amendment of adding the emergency clause.
There's been a motion of ought to pass as amended with an emergency preamble. It's been seconded by Representative Lookner. Will, the only thing I'd like to add to that is, as long as we get the crux, the intent of this written amendment, that the state is now authorizing EMS agencies to, possess, distribute, et cetera. I think that works, and that should give you what you need, right?
Yep.
Okay.
Just one question.
Yes.
I missed a little bit of it in the first part, and I just want to make sure I understand it. So this is going to be still going through a rulemaking and before it gets approved, correct?
Yeah, so there's going to be a statute that is going to say that the EMS has the authority, and I'm paraphrasing EMS, but emergency medical providers have the authority to possess, distribute, administer controlled substances, and that the board will make the rules around how that is done. And so we're saying you have that authority. What that authority exactly looks like will be done through rulemaking. But, and in doing so, then they'll go to the FDA the DEA and say the statute gives express authority for them to do it. The rulemaking process may not be done yet, but this meets the needs. Did I summarize that correctly, Will?
Okay.
Okay.
Right.
And on language review, I think we can tighten up anything that needs to be tightened up, but we all understand the intent.
And then just
Needs to
given
be
the quick nature of the turnaround time, which is understandable, just if I could have the committee's permission in case some language, some drafting things come up to discuss with Director O'Neill or
Yep.
EMS agencies that might be appropriate for assistance.
Yes, yeah, and if you need to discuss it with the DEA too, or whoever you need to discuss it with to get the language right, that'd be fine. Okay, are we ready to vote on this? Okay.
LT 484, the motion is sought to pass as amended by Representative Perkins and seconded by Representative Lookner. Representative Hasenfuss.
Yes, ought to pass as amended.
Yes.
Representative
Yes.
Yes.
Bobby.
Yes.
The motion is sought to pass as amended.
Yes.
He says yes out of line. Representative Perkins. I was just letting
There's
you
a
know what we
preview.
were doing. Representative Perkins.
Aye.
Representative Perkins says aye. Representative McIntyre.
Yes.
Representative McIntyre says yes. Representative Ardell.
Yes.
Representative Ardell says yes. Representative Bunker.
Yes.
Representative Bunker says yes. Representative LaJoy.
Yes.
Representative LaJoy says yes. Representative Milliken.
Yes.
Representative Milliken says yes. Senator Curry, if you changed your mind.
Do I get two votes? Yes.
Okay, we have 12 in favor of the motion and Senator Bibi Center is the one absent. Thanks.
And thank you, and thank you for bearing with us. I know a lot of you are here to testify for the public hearing for LD 2232. And so without further delay, we will open the public hearing on LD 2232, an act to increase county jail funding. And this is a committee bill. I believe I am the sponsor of this bill. But I feel like we all understand this well enough so that I'm going to skip over my introduction of the bill and open it up directly to members of the public and the legislature. And I did promise Representative Strout that because she has an appointment that she needs to go to, that she can come up and testify on this bill right now.
Even if I'm against, I'm just kidding.
Yes, yeah.
Good afternoon, Representative Hasselfuss and distinguished members of the Criminal Justice and Public Safety Committee. I am Representative Tiffany Strout from Harrington, representing the towns of Millbridge, Harrington, Columbia, Columbia Falls, Centerville, Addison, Jones, Fort Beals, Jonesboro, Roque Bluffs, Whitneyville, and Machias in beautiful Washington County. And I'm here today to testify in support of LD 2232, an act to increase county jail funding. Thank you for the opportunity to testify today in strong support of LD 2232, a bill that will help to ensure residents of a county jail are cared for and will help to relieve some of the property tax burden locally. It is unfortunate to have to ask for additional funding for jails, as I would rather see additional funding go to schools and education and provide opportunities for individuals. So hopefully people do not have to spend time in the county jail. However, this is not the current place where we are at in our society. With the lack of mental health facilities, the drug epidemic, and seasonal work, Washington County has been struggling to keep up with all of the funding needs to keep the county operational. Mismanagement of county taxpayer funds for several years put Washington County in a position where they are almost not able to pay for their tax note back to the bank. This required the immediate tax increase on those who pay property tax to make sure our jails, courthouses, dispatch, and sheriff's office all stayed functioning and able to protect the citizens. Being a member of the Washington County Budget Committee, I was able to see firsthand the exorbitant costs associated with running the jail. When looking further into the expenses, the driving contributor seems to be in the medical costs. I understand medical coverage falls under the federal government guidelines, which means once you enter the jail, you lose all of your medical coverage, but does not mean you are cured from all of your medical needs. And in fact, some receive medical assistance that they would not otherwise have received if they had not gone into the jails. The costs are then passed on to local taxpayers to cover. The state providing funding to the county jails helps to offset the mandated medical cost coverage as well as needed maintenance for the county jails as they age. Funding the jail is a small part of a larger problem that should be looked at. There needs to be more funding for mental health and treatment centers, more judges to process individuals so they did not spend any more time in jail than mandated by their crimes and sentences. There needs to be more opportunities for education, opportunities for people to succeed. As all these issues continue to be worked on, the state providing funding, which I do understand is also taxpayer funds, helps to alleviate some of the financial stress on the property taxpayers, which are often retired and on fixed incomes and already have to make decisions on purchasing medications of their own or keeping their homes. Thank you for your time today, and I would be glad to answer any questions.
Thank you, Representative. Are there any questions? I see a question from Representative Milliken.
Thank you, Mr. Chair. Thank you, Representative Strout. This might be a weird curveball question that maybe you can't answer on the fly, but might be interesting. The judge that serves Washington County recently is leaving the bench. Do we know from Washington County if there's an anticipated increase in the county jail expense due to a lack of, you won't have a judge soon?
I mean, I can give opinions, but
Yeah.
I think that system, there's other ways that could be fulfilled with that system to help process. I've sat with actually the sheriff and one of the defense attorneys, and I'm trying to get through some of that workout. It's not necessarily more trial days, it's more frequency of those judges coming into the county that would then in turn be able to see people more frequently and process them for accurate sentencing, which would help to alleviate some of that cost. But with retiring judges, unfortunately, it looks like there may be some delay in that, which in turn will continue to put costs on the county. Non-professional judge related answer.
Thank you. Thank you, Representative. I don't see any further questions.
Thank you very much.
So with that, we'll open it up to other individuals who would like to testify in favor.
Thank you.
Where's that? Thanks.
Thank you, Senator BB Center, Representative Hassenfuss, distinguished members of the Criminal Justice and Public Safety Committee. My name is Will Toole. I represent nearly 24 small towns and villages in central Washington County, and am here today who are plagued by soaring property values and small tax bases with low or fixed incomes. Put simply, many of my constituents in House District 10 are living on Social Security, a pension, from paycheck to paycheck, and or can't take any more costs being pushed down to their county or their towns. That is why I'm here today in support of LD 2232. You all have seen the news about Washington County's fiscal crisis. I and my colleagues in the county's delegation who have lived it firsthand for months and have seen how debates over county finances have torn families, employees, the county, and our communities apart. We all want the best for our small rural county, and we all want to be part of the healing process. Part of that process is understanding just how much mandated increases in services at small county jails like ours force county budgeters to increase spending and pass those costs on to the people of our state and those of us who represent Washington County here in the legislature that we all serve. The issue of county jail funding is not a new one, and Washington County is not alone in dealing with it. But we are the extreme case of what will happen if counties can't function, if costs Augusta passes on to the counties continue to grow unabated. And so I'm here today asking you to support this badly needed funding in hopes that it will allow counties to provide the services the legislature has mandated that they provide, and to do so without further burdening the grandmother on Social Security or the retired veteran who just wanted to live quietly and peacefully in the woods. I ask you to do it for the lobsterman who has seen the value of his catch decline, or the kid coming out of school looking to build a little house on land his or her family has owned for generations. And I ask you to consider that Washington County is not alone. Waldo and Penobscot counties are also in dire straits financially due to the high costs of county corrections. Others may not be grabbing the headlines, but this funding will help each county from passing on even higher property taxes to their towns and residents. Before I close, I want to share with you something our county manager sent along to our delegation last week. We need more court days down east. More court days means defendants get their day in court faster and spend less time in jail waiting for the case to be heard, and sentences, if they are found guilty, to be handed down. That means less overhead for our county jails and helps both the justice system, the county boarding inmates, and taxpayers alike. I realize that's not this bill, but would be remiss if I didn't pass along our county's request before you, as I know there is much collaboration between yours and the Judiciary Committee. I thank you for hearing me out, for listening to a cry for help, and ask that you do right by our counties and municipalities that are struggling under the weight of county corrections costs. And I'm happy to take any questions before I scoot back over to state and local.
I don't see any, Representative Milliken.
Sorry, thank you, Representative Tool. Is there still an enormous backlog of cases in Washington counties?
I believe that was the subject of a letter that we all received last week from the commissioners and from the commissioners in particular, that there is still quite a backlog, that there is a limited number of court days. And as I recall, some court days have been canceled, and with Justice Stewart retiring, that has caused further issues with those. So people are being incarcerated, whether they're innocent, guilty or innocent, or is not the question. It's they need to be tried, and they need to go through the system, and their case needs to be disposed of. And that's the real issue one of the real issues that the counties are facing, and along with the medical costs. And there's a whole long laundry list that a lot more people who have a lot more knowledge than I do can speak to that. But it's important that we get cases tried faster.
Couldn't agree more. Thank you, Representative.
Thank you.
Thank you. And is there anybody else who'd like to testify in favor of this bill?
I'll step forward since they all jumped in front of me, right? There you go.
I will say I am letting slide the rule that legislators
Thank you.
are supposed to go
Thank
at the end,
you.
but
I appreciate that very much so. So good afternoon, Representative Hassenfuss and distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. I am here to testify in support of LD 2232, an act to increase county jail funding. The bill addresses a growing and unsustainable imbalance in how we fund county jail operations in Maine. For years, state funding for our county jails has remained largely stagnant, while the cost of operating those facilities has continued to rise significantly. As a result, counties have been forced to make up the difference, placing an increasing burden on local property taxpayers. The bill makes several important and necessary changes. First, it increases the base funding for the County Jail Operations Fund from $20.3 million to $28.3 million beginning July 1st, 2026, and establishes a modest but critical 4% annual adjustment moving forward. This provision recognizes a simple reality: costs do not stand still. Without a predictable funding mechanism that keeps pace with inflation and operational demands, counties will continue to fall behind. Second, the bill provides an additional $5 million in dedicated funding for community corrections programs, including pretrial supervision, alternative sentencing, and electronic monitoring. These programs are not only cost-effective, they are essential tools for improving public safety outcomes. By supporting alternatives to incarceration where appropriate, we can reduce jail populations, improve rehabilitation outcomes, and ensure that limited correctional resources are used where they are most needed. Third, the bill refines the funding distribution formula to rely on the most recent prior fiscal year with complete data. This is a practical and common sense adjustment that will improve predictability and fairness in how funds are allocated among counties. Taken together, these changes represent a thoughtful, data-informed approach to strengthening Maine's correctional system. They support both the operational needs of our county jails and the broader goal of a more effective and efficient justice system. To give you an example, in Washington County, our rated capacity in our jail is 42. available long-term beds. In 2024-25, our average daily population was 45. To date, from July 1st, 2025, which is the data used for current funding, our ADP, or available average daily population, is 59. Thanks to the limited 21 judge days, as Representative Milliken mentioned, per year. However, that's another issue in itself. At one point in time, we actually had 13 accused of murder that were sitting in the Washington County Jail waiting trial. And so things like that just kind of added up, and that's where we end up as much. So the cost of housing residents, as they're termed today, without any increase in reimbursement from the state, coupled with the cost of healthcare services, as Representative Toole mentioned, including our substance use disorder treatments, we continue to see cost rise. The jail itself results in 30% of the overall county budget, and we have to pass that cost on to our county taxpayers. It's the largest line item, so to speak, of the departments that's in our bill or in our budget. It is important to emphasize this is not simply a county issue. It is a statewide responsibility. County jails serve a critical function within Maine's unified correctional system. When the state does not meet its share of that responsibility, the impact is felt directly by our local taxpayers and ultimately by the safety and well-being of our communities. Finally, the emergency preamble underscores the urgency of this issue. Counties similar to Washington County are already feeling the strain. Without timely action, these challenges will only intensify in the coming fiscal year. For these reasons, I urge the committee to support LD 2232 and advance this important legislation. Thank you for your time and consideration. I'd be happy to answer any questions that you might have.
Thank you, Senator. Senator Seaway.
Thank you, Mr. Chair. I just was wondering, on electric monitoring, you know what the success rate is of that? I know we had an Assistant Attorney General actually left and he had electric monitoring and it didn't work. And I've known some other issues that happen that way.
And I don't know the numbers on that, Senator Searway. That would be something that we'd have to maybe ask either someone coming from behind.
Yeah.
I know that that is one of the methods that is used.
Right.
And right now they are actually, I think it's representing like up to 25% of the monies that they do get, they can use for these alternatives. And so that's why that extra fund would come in handy and not have to be utilizing the funds that they are getting. But I'm not sure of the success rate. I'm not even sure of how much it's used, to be honest with you.
Right. Okay. Thank you.
Mhm.
Thank you, Senator.
Thank you. Thanks for the option to go first or go with that first bunch. Thank you.
And just a reminder to have everybody sign in if they can when they come up, but.
Here we go. That should be 20 there. I think.
So good afternoon, Representative Hassenfuss and distinguished members of the Joint Standing Committee on Criminal Justice and Public Safety. I'm Michael Ray, and I represent the towns of Appleton, Islesboro, Liberty, Lincolnville, Montville, Morrill, and Searsmont in House District 40. And so I'm here to express strong support for LD 2232, an act to increase county jail funding. I'll be very briefly, things that you've heard before, of course, that property taxpayers in Waldo County and across the state, as you all know, have been taking a big hit in recent years. It's painful and extremely burdensome to many as everyday prices just keep rising and rising and rising. With this bill, the legislature can help ensure that the cost of maintaining Maine's correctional infrastructure is shared more broadly across the state's tax base rather than concentrated on the property taxpayers of individual counties. So LD 22 is as much about tax fairness as it is about addressing the rising costs of maintaining a safe and sustainable correctional system in the state. An increase in state funding shared by all taxpayers in the state will keep pace with inflationary and mandated concerns that our counties face. as well as continue what I think is the equitable model of state and local government partnerships. Thanks for your time today, and I'd be happy to try to answer any questions. One thing that isn't on paper, which I'd like to share with you all, is that, like probably many of you, I happen to represent proudly the town of Lincolnville on the select board, and I deal with municipal budgets. Okay, so when you feel, as you know, when you're feeling the pressure coming from up above, excuse me, of the county budget, the education budget, and what the big hit that that's going to take on your neighbors, one tends to be a little less bold in one's budgetary values, I guess you could say. And capital improvements, necessary services take a hit. That's just human nature. Thank you very much.
Representative Lugner, do you have a question?
Thank you, Mr. Chair. and Thank you, Representative Ray.
You bet.
Since we are talking about tax fairness here, there's a big discussion about what sources of revenue would be more equitable. Do you see other methods that we could, raise the desperately needed revenue? Like how do we go about doing that?
You're asking the wrong person, for one. And I do think that generally sharing things more broadly, because it's a state service, county jails are, I think, basically lessens the burden and makes it less concentrated and more fair and more equitable on individuals. But as where that revenue is coming from, I can't say. I'd like to be able to give you an answer, though.
Thank you, Representative Milliken.
Thank you, Mr. Chair. I don't have a question for the good representative from Lincolnville, but I have an information request. Is that appropriate? I assume the 4% increase is to basically a mirror of the 4% increase that counties can raise for their jail budgets. And that's where that number came from. And I'm curious about the history of that number being used for that. You know what I mean? Okay, thank you.
Wow. Thank you. Yeah, whoever would like to take the podium next. You guys can arm wrestle for it.
Good afternoon, Representative Hassenfuss and members of the Criminal Justice Public Safety Committee. My name is Tim Curtis. I'm the Somerset County Administrator, and I also serve on the County Corrections Professional Standards Council. It's a privilege to be able to speak to this, and I want to say thank you very much to the committee for the cooperation that we've received over this session. Not only your recommendation to go to appropriations with the monies from LD 852, but also putting forth this to further this discussion. I believe Senator Moore pretty much gave my testimony. She hit on every point. And so it's very encouraging to see the legislative support from some of the counties that are working their way out. Let me just add off the cuff here. Washington County has done yeoman's work to right the ship in that county. When this legislative session started, we were talking about bankruptcy. Now we're talking about they've secured their tax anticipation note. They have cash flow coming in. They're able to provide their services. So the commissioners, the administration, the staff there in Washington County has done a great job. And Waldo and Penobscot are continuing that fine work as well. If this language looks familiar to you, it is because it was part of the attachment to the LD 719 report, where the Standards Council, with representation from the Sheriff's Association, the county commissioners, the Department of Corrections, Maine Municipal, all put their thoughts together and say, what are some of the things that we need to address immediately? Moving the baseline from 20 million to 28 million is the emergency. That is the funding that will restore upwards of 20% of jail costs being paid by the state and alleviate property taxes. We feel it's essential moving into the next administration and the next legislators that will have to deal with budgets to move that baseline up to that amount. The annual increase of 4%, again, that is something that, however it's manufactured, it essentially lessens the burden from counties to have to go through this exercise at every legislative session to increase jail funding. County corrections, Senator Moore dealt with that. Currently, the structure is 25% of the existing 20 million. So that's where the 5 million comes from. If that's not changed, if that county community corrections money is not separated out and the 25% remains, it now becomes 7 million of the 28 million is dedicated to community corrections. Not anything wrong with that, but it takes away from or eats into the jail operating fund for each of the counties. And based on the report to the jails from the Department of Correction last year, jails are already spending in excess of $7 million to ensure community corrections. Finally, the last item in there has to do with essentially changing the timing of the distribution formula. The distribution formula is complex, but basically it is data that is derived at the end of the state's fiscal year to determine the county of origin of every inmate, not your daily population. So counties, the 28 million will be distributed to the counties, not based on their ADP, but based on where the inmates came from originally. So that has to be calculated. Because of the timing to do it after the current state's fiscal year, it creates a gap where half of the counties don't know what their funding will be when they set their budgets, which is around this time of the year. Simply moving that back to the most previous fiscal year, the data will be pretty close to the same, and counties will be able to budget without running into shortfalls, which they have in the past. Aroostook County, Kennebec County have run into shortfalls by guesstimating what their state revenue would be, and then the shortfall because those numbers are adjusted. So that's the simple. I think that's the simplest fix in this entire bill, but I'd be glad to take any questions, and I'd be glad to make myself available for the work session. Thank you.
Thank you. Are there any questions? I don't see any questions. So thank you. It was Commissioner, right?
No, Administrator.
Administrator. Okay. Sorry.
I'm appointed, not elected.
Okay.
Chair Hassenfuss, members of the committee, my name is Jim Cohen. I am a partner with the law firm Verrill Dana, and I serve as legislative counsel for the Maine County Commissioners Association. There are several commissioners who are here today. I drew the card of speaking to you all this afternoon. We are here in support of LD 2232. I think you've heard a lot of important information both in this bill as well as prior bills this session. Unlike schools where there is a 55% state level of support that is in statute, and unlike municipal revenue sharing where there is 5% of sales tax revenues that gets shared with municipalities, there is only a flat number in statute, and that is the 20.4 million. That was a number arrived at in 2022 after a lot of work from members of this committee, members of the Department of Corrections, sheriffs and county commissioners and administrators to come up with that number. But it always contemplated that additional funds could be allocated by this legislature. Back then, the state provided on average 20% of the total cost of operating jails. But as you can see from the testimony that we've provided today, as well as prior testimony, that percentage keeps dropping. And what we're looking at currently for 2027 would be only 14% of jail costs. What does that mean? Well, as the number of individuals being incarcerated goes up outside of the control of counties, and the number of admissions has gone up 40% in 5 years, not in the control of counties. As medical inflation goes up, not in the control of counties, the costs have gone up, and they've gone up tremendously. So when state support is flat, the only other place to look to is the property taxpayer, and that's where counties have turned. But there's also a tax cap, which says counties can only raise so much from the property tax. So when that runs out, they have to turn to their reserves. And many counties are now confronting running out of money in the reserves. When that money runs out, there is no other place to go. We don't have an answer to the question, what happens when all of these sources have been exhausted? So that's the challenge. That's the crisis before us. LD 2232 tries to put in place something more like the 20% for school funding or the 5%, something that says over time there is going to be shared support from the state and from the local property taxpayer. The last thing I want to point to is at the end of my testimony is a chart you've probably seen before, which is illustrating how county jails are part of what is really the state's criminal justice system. The legislature decides what's criminal. That's outside of the counties. Courts decide whether somebody is held with or without bail after arrested. Other agencies are deciding who gets arrested. Courts decide whether somebody is guilty or not and how long they'll be sentenced for. All of those things are part of the state's justice system. The Department of Corrections sets the standards by which jails must operate. And this legislature has also established those standards. This is a shared system. It is more state than county, but the funding is the reverse, where the funding is local. So this bill is certainly one path to try to address that, and we would encourage the legislature to move forward with this or something similar to it. I'd be happy to answer any questions.
Representative Lookner.
Thank you, Mr. Chair, and thank you, Mr. Cohen. We discussed briefly before the hearing. I think it'd be really helpful for me during work session to see the actual numbers of how it's gone up. But I also think we need to see the numbers before the pandemic because they really went down. Numbers really went down for those 2 years. So I don't know that it is 100% accurate to say that, over baseline, we've sort of gone up 40%. If we have gone up 40% in residents in our county jails, why are we prosecuting so many more people? What laws have we enacted that, we're sending so many more people into jail? Or is it that we just don't have services like, so anyway, I want to see a bigger picture here. Anybody who can bring that to the work session.
So thank you, Representative. And I assume what you're referring to are the figures of individuals who are incarcerated over a longer time frame than just the 5 years, if I'm understanding correctly.
Well, yeah, I'd like to see 2018, 2019, and because the numbers really did, we let a lot of people out of the jails during the pandemic for, obvious reasons. So just looking at FY20 and FY21, I don't know that it really gives us a whole picture.
I appreciate the question. Certainly, we'll do our best to come back with that information. If you look at what are the cost drivers, certainly the number of admissions is a factor. Representative, you mentioned more prosecutions. That is a consequence of more people getting arrested. It is a consequence of a range of factors outside the control of counties. It's also a factor of the kinds of individuals who are being arrested, that more and more of them present with substance use disorder problems, present with mental health problems, and that the inflation around those particular aspects has gone up way faster than the costs, than other elements of the breadbasket that make up inflation. I would also point to a data point that county jail costs have been going up slower than the Department of Corrections costs. Everyone is doing the best they can, but the kind of individuals being served by county jails, they're coming in, they're leaving, they're coming back. So each one of them is a little bit more costly to serve while they're there. So it's a range of factors of which admissions are a piece. Thank you.
Representative Bunker.
Thank you, Mr. Chair, and thank you for being here on this.
Thank
I
you.
want to be sure I understand on this particular legislation and the amounts suggested. This does not represent the true long-range fix, if you will. This is more of an immediate need. And probably it's premature for me to think that going forward, we've yet to come up with Department of Corrections contributions to county corrections shall be X% of the total amount of actual operating expenses, much like the 5% or 55% of school funding. I guess long range, that's a longer point that we look to, but it's not in this session.
Yeah, no, thank you, Representative. And I guess the first part of the bill, which would raise the floor to 28, does represent that immediate fix, because that would happen now. The second part of the bill, which would say there's a 4% increase each year, that is part of the longer term way in which the state share is maintained. Now, ultimately, whether that's the perfect answer is, I think for all of us to sort of weigh in. I think originally LD 719 took a different approach, and that was to say 20% of the required costs of operating jails, which number could go in theory down as well if costs went down, but modeled a little bit on school funding, where the state pays 55% of the required costs. Municipality schools can choose to invest more. LD 719 was framed in a similar way, which is whatever is the required cost, 20% of that. I don't know that counties are looking to spend more than that, but at least it ensures that if there's some amount in addition to what's required, that wouldn't be covered. So that's another approach. But this bill has just the 4% escalator, which is another way of getting at the same long-term challenge.
Follow up, if I could. Tell me where the current 4% cap from counties down to municipalities, how that relates to this one. Does that original cap go away and this is instead of it, or are they both in play?
To some degree, it's merely coincidental that the number that's in the bill is 4% and the tax cap of 4% happen to be the same number. So the language that's in the bill is in the corrections code. The tax cap is in the municipal code 30A, and this bill does not change that tax cap. So there's still a limitation that says a county for their jail costs is allowed to increase taxes on an annual basis of 4% or the growth factor, whichever is higher. And then that resets every year. So this bill does not propose to change that.
Okay. This is the percent by which the state's contribution would increase by 4%.
Correct.
Gotcha. Thank you.
Representative Milken.
Thank you, Mr. Chair. Maybe to save our analysts some time, do you happen to know where that 4%, that number came from, the 4?
Why 4%?
Yeah.
That came from the County Corrections Professional Standards Council and just sort of looking over time. It's not, I'm not aware that it is a magic number, but I think it was probably looking at over time. Plus, there is some symmetry with Title 30A and the tax cap. I don't believe it is a magic number.
Thank you.
You're welcome.
Thank you. And Mr. Cohen, it's a very exact number, the 28,342,104. What does that exact number represent?
I think that was an effort so the County Corrections Professional Standards Council had recommended 9.3 million to try to keep pace with the 20%. I think 8%, 8 million is a rounder number. It happens to coincide with the amount that was in the supplemental budget of 4 million plus the 4 million that was LD 852 combined is 8 million. So it's roughly an $8 million increase over what's in current statute. And I think the goal is to get the state's share closer to 8%. Sorry, to 20%.
So and so back when the 20% was first put in statute, the 28 is ballpark that 20%
You mean the
number.
20 million?
Yeah, when the 20 million was put in statute, based on the 20%, the 28 is ballpark 20%.
For that fiscal year, and then the 4% is intended to kind
Yeah.
of keep pace with that.
Thank you, Mr. Cohen.
Thank you.
Good afternoon. Representative Hassenfuss, distinguished members of the Criminal Justice and Public Safety Committee. My name is Amanda Campbell, and I am submitting testimony in support of LD 2232 on behalf of the Maine Municipal Association's 70-member Legislative Policy Committee. For the 132nd Legislature, our LPC proposed a slate of priority platform bills aimed at reducing property taxes for all Maine property owners. Included in this platform was LD 852, an act to reduce the property tax burden by adequately funding county jail operations. Although the bill's language changes were removed during the committee amendment process, LD 852 maintains a funding request and currently sits on the appropriations table with a fiscal note of $8 million, appropriating $4 million in each fiscal year 26 and 27. The LPC thanks this committee for their consideration of that funding as part of the report back to the Appropriations and Financial Affairs Committee as they deliberate LD 2212, the supplemental budget. As originally drafted, LD 852 also proposed to increase baseline funding in fiscal year 26 and to tie future ongoing funding to the Department of Corrections budget for state correctional facilities at a rate of, you guessed it, magically 20%. This bill does not do that. In response to the directive provided in Resolve 2025 LD 719, the County Corrections Professional Standards Council, on which MMA holds a seat, presented a report required by the Resolve, which directed the council to report back to the committee on several factors involving county jail operations, including future needs for state support to county jails and regional jail operations. The language included in 2232 is taken directly from that report as recommended by the council. The state's baseline budget for county and regional jail operations has stagnated at 2021 levels, now representing only 15% of the total $130 million in fiscal year 2025 jail costs, although approximately 80% of jail operations are dictated by the state. The proposal in this bill increases that annual baseline funding to just over $28 million and includes a 4% annual inflationary adjustment. Additionally, the bill eliminates the requirement that jails dedicate 25% of the baseline funding to community corrections, instead providing an additional $5 million in funds to be used exclusively for those programs. It is important for legislators to understand the impacts of county services on the municipal budget. In a presentation to the Real Estate Property Tax Relief Task Force, MMA shared an overview of the property taxation process from a municipal perspective. Of note in that presentation were the three main cost drivers in a municipal budget, of which the county budget is one. Due to limited state resources across all areas of county government, and in particular, the functional decrease in county jail funding, counties rely heavily on property taxpayers to fund operations. Increased ongoing funding for jails is critical to maintain optimum levels of service at Maine's 15 county jails and to reduce the reliance on and the burden to the local property taxpayers. Again, the LPC thanks the committee for including the appropriations of LD 852 in their supplemental budget report back and strongly encourage the committee to vote ought to pass on LD 2232. Thank you for the opportunity. I'm happy to answer questions now or at the work session.
Thanks, Chairman.
Thank you, Mr. Chair. So if you just went 20%, that would cover it.
You're asking the wrong girl.
Well, I mean, it's pretty close to what you're asking for, right?
What this bill has done is essentially move that baseline funding to represent the magical 20% that was never written down when the baseline was originally put into statute. Yes.
So what I'm trying to say is, to me, that's what the intent was before. And if we can just say the 20% instead of these little figures and keep it that way and do like we've been doing in the past, it should take care of it. But I'm just wondering, should we be putting the numbers or should we do the 20%?
I would leave that
That's the
conversation to the committee.
All right, thank you.
But I appreciate the question.
Representative Lookner.
Thanks, Mr. Chair. Thank you for your testimony. last session, the county started coming to us and saying, jail costs are out of control. And I was of the mind back then that, the counties have different means at their disposal of raising revenue. And here we are now, and it seems like, well, their means of raising revenue is property taxes. And this is a property tax bill. Would you agree?
Yes.
It's very, and I want to see property tax relief for folks, but also, so with that in mind, like, why aren't we looking at other sources of revenue, other ways of funding municipalities? Why does this just have to be a general fund appropriation?
Well, I would argue that in my general sphere of taxation, which is where I spend the majority of my time during session, we've put lots of bills forward to try and get approval for additional dedicated revenues or local option sorts of revenues, and none of them have been met with any success.
Thank you for saying that.
Representative Bunker.
I'll join the parade on trying to lessen the impact on property taxes. It's so easy to beat up on county government. I do that on my municipal budget committee. And then I go in and join the county budget committee and I beat up on the state for their issues. I'd be interested on the side, not now, for later on, the real estate property tax relief tax force that you make reference to.
Mhm.
And obviously this is one of the main drivers. I'd be interested on the side what the other two were, and if there are any strategies coming out of that we might look to other than the jail issue.
Do you mean representative recommendations from the task force themselves? Okay, I'm happy to send you along that report if you'd like.
Thank you.
Representative Bunker, I do know somebody who is working on that task force who
also happens to have a birthday today.
So it's a credible source.
Well, I'm not sure if I would go that far.
I wouldn't go that far.
Well, thank you very much for your testimony. I don't
Thank
see any
you.
further questions.
Thanks a lot.
I do see a few more individuals who I think would like to testify, or maybe they're just here for moral support.
I was really here for moral support. I know my role, and we were going to fix on operational and allow them to talk financial, but we did want to answer just a couple of questions that may have. My name's Troy Morton. I'm the sheriff of Penobscot County. Also, I have the honor and privilege to serve as the president of the Maine Sheriff's Association. The testimony that you've heard today is outstanding and really outlined some of the issues that we've had, the counties have had for some time. The Maine County Commissioners, county administrators, MMA, and even MDOC have worked to try to address this. Representative Lookner had a great point of, was this last session that we dealt with this. We've been dealing with this for decades, and we never find the perfect solution to keep doing this. Property taxes are taking the beating. I'll leave that to the folks behind me to talk about the numbers. The one point that I did want to make to you folks today, the question that often comes up, what are the counties doing to reduce your cost or manage your operations? Folks, we've done everything that you've asked. You asked us to start MAP programs. We have the most extensive treatment programs in arguably in any treatment facility there are. You've asked us to do pretrial, electronic monitoring. We've done it all. We've done day reporting, came here and changed laws, as you remember, with a former Representative Danny Costain about day reporting. We've done that. We have continued to change our operations. We've worked close with MDOC to try to figure out other ways to reduce our populations. Here's an interesting fact. Our populations have trended downward since COVID, but one of the interesting facts that have not changed is our admission rate. We can't lose track of our admission rate. One of the dangerous things to look at is the amount of individuals in the Penobscot County Jail or many of the county jails are steadily coming in. And some might argue that our bail code changes are forcing them out the door so fast, not prepared to be back on the streets, only to be rearrested. You're seeing it every day in the news when we have multiple bail violations. So again, I just want to share with you, we've continued to be creative. The Professional Standards Council is an excellent tool for us to continue to move forward. We'll continue to do that. We'd love to hear recommendations on how we can do things differently. But our biggest cost drivers are things we have no control over. And this isn't pointing fingers. The judicial system and the courts, that's a fact. The state's mental health facilities and low empty beds in those, not because they're not trying to help us, but they might not have the capacity to handle some of these folks. That's a fact. The individuals coming into our custody today, our laws and processes have removed low risk, no risk people. Individuals coming in today, unfortunately, are checking every box. There's violence, there's mental health, there's substance use, there's failure to every program we've tried. And therefore, we're dealing with people incredibly expensive to manage. You've heard us say this 1,000 times, and I'll end on this. County corrections are the emergency room to the entire criminal justice system. And we need help with that. I love the ideas of we have to move this off the back of property taxes. We've brought forward suggestions year after year on how to fund it in other ways and never were able to get there, to the point that counties are breaking now. With that, I'll take any questions, and I know that will be more valuable to you during your work session if you're looking for certain information.
Senator Curry.
Thank you. And I'm not sure if this is the right question for you, but
Sure.
I'm just working through some of the numbers here, and I've had a long conversation with my sheriff and my county commissioners who are facing this struggle, and I'm in support of added funding for the county jails. When I look at the ask in my head, I've been thinking this is like 20 to 28, $8 million get us back up to 20%. But the 5 million, pulling the 5 million out of that, it really the math I quickly just tried to do. So was that we really have right now, the state is investing 15.4 million in county jails because 5 million is in community programs. And the ask is to go from 15.4 million to 28 million. Is that correct? Is that what? So we're doing like a 80, 84%, 85% increase of what the counties need.
So
and then having from 15.4 to 28, and then having all the community corrections programs separately funded. Am I getting the math right of what you're saying we need?
To be fair, the people behind me
Okay,
are
good.
far more suited.
Dodge that
And-
one.
And as much as sheriffs know all, in this case, we'd be wise to let those that are managing the money address that.
Really happy to have that.
Thank you. Sure. Thank you. I know what you meant, sir.
Senator Seaway.
Thank you, Mr. Chair. Just, back when I was assistant jail administrator, it was 20%. I was looking at 20, 21, 22, they're all 20%. And then it started dropping 18, 17, 19, 18, now it's 14.8%. So why aren't we putting it back to 20%? That's what I'm asking.
Well, I think that's, again, the financial folks behind me are
Yeah.
really advocating for that. And I think one interesting fact of that is, if you go back and look at when we were managing a higher population of less risky people, some of those less risk offenders didn't come with the cost, right? So although the population's gone, some of them were traffic violations, night hunting violations, things like that are no longer in the jails.
Right.
But the individuals that are staying in the jail are requiring tremendous amounts of services.
Right.
And so therefore the cost, and that's why it's not fair to just look at the population. You have to understand what we're trying to manage.
And the thing is I was listening to Commissioner Liberty say that, when they reduced their population, their costs still stayed the same. So that, to me, said the same thing in the jails.
I think it's fair because we are dealing with a different population. I don't live in the MDOC world,
Right.
but I believe they have the same challenges. Population may be different, but a lot of the folks that we're managing today come with a lot more challenges than we did a decade ago.
Yeah. Thank you.
So we're happy to come back during work session if there are data or questions that you may have.
Thank you, Sheriff. I don't see any further questions. Is there anybody else who would like to testify in favor of this bill? Legs asleep.
I don't have testimony. It was entered into the portal,
Great. Good thing. That's it. Thank you.
and I'll be brief. Representative Hasselfuss and members of the committee, I'm Chris O'Neill from Portland, and I'm here to testify in favor of the bill on behalf of the National Correctional Employees Union. The testimony submitted by Executive Director Bill Doyle is there for you to read, and it's brief. It's one page, but he makes a couple of points that I think would be worth your while to look at. When you began this legislature, and again, this session, you had several imperatives in the room. You just had a study report come back saying that there's only so much that the legislature can do to mitigate property taxes. And one of the named recommendations that they had was funding of the jails. NCEU believes that this will greatly enhance our ability to recruit and retain personnel at a time when just York and Cumberland County alone are down approximately 100 COs, which is not a good situation. The communications and patrol arms of the budget are not limited by the cap the way that the COs are. So this is welcome funding. With not a whole lot that you can do, you often have heard people say, you know, what can we do? And this is one of the things that you can do that will be impactful. I once had a spirited argument with a former governor 20-something years ago here, where he said, Chris, I know it's not perfect, but the people need to think we're doing something. You'd be doing something here, but you'd be doing something meaningful. So we wholeheartedly support the bill, as opposed to some of the other things that you may or may not be able to do. Be happy to answer questions if you have them.
I don't see any questions, so thank you, Mr. O'Neill. Is there anybody else who would like to testify in favor of this bill?
Representative Hasselfuss, distinguished members of the Judicial Committee. I'm not going to read all my testimony because you've heard everything a dozen times already. But I just wanted to show face here in support of this. I'm Representative Arthur Mango from District 9, Eastern Washington County, and you know the financial condition that our county is in right now. And obviously we need all the help we can get. So if there's any questions, I'll leave it for the next person.
Thank you, Representative Mingo.
Thank you.
Is there anybody else who would like to testify in favor of this bill? I don't see anybody. Is there anybody who would like to testify in opposition to this bill? Anybody who would like to testify neither for nor against this bill? I don't see that there's anybody online. So with that, we can close the public hearing. We have a few additional things scheduled today. I do want to say that there's a possibility that we may take this bill up for a work session this afternoon as well. So if anybody would like to stick around to be here for that or work with Will to answer any of those questions that were just proposed, that may be on the agenda for this afternoon. And with that, let's take a break, 15 minutes or so. Try to get a little bit of caucusing done, stretch our legs, and then we'll come back and deal with the work sessions and discussion listed on the schedule and potentially taking up the last bill for a work session as well. This one. All right, thank you. Thank you, everybody, for coming back this afternoon. I am going to take a few things out of order because I'm going to try to do, and I can't promise that I'm going to be great at this, but I'm going to try to take the things that we can get disposed of quicker. So if quicker, so I'm going to try to do the things that I think we can get done and have a final disposition quicker. So what I'd like to do is I would like to have a work session on actually, what I'd first like to do is have a committee discussion and potentially a work session on 1918. And then I think if we go to 2232 and have a work session on that, and then if we go to 2058 and then 2165, my prediction is that 2165 is going to take us the most time, with 1918 taking us the least time, and then in sequential order thereafter. I could be way off on that prediction, but that's at least what I am going to try to do. And for those of you who recall in our discussion last week, I said that I would like to have somebody second me in a motion to reconsider 1918. And so I'll make a motion to reconsider 1918. Representative Milliken, are you seconding that? All those in favor of reconsidering 1918? I think that was unanimous except for Representative Perkins. Yes, so it was everybody except for Representative Perkins. And so with that, we're opening a work session again on LD 1918. And I do see Ms. Burns and Attorney Morgan here, Attorney Burns and Attorney Morgan here. And as I noted to the committee last time, I believe that there was some misunderstanding, in part due to what I was saying about OUI cases and a lot of pleas on OUI cases that are for driving to endangers. Those are still criminal, and there would still be a criminal record for that. And I think to steer our focus, we're dealing mostly with, some Title 12 infractions and some other things. And so I don't know if Ms. Burns or Mr. Morgan can come up and speak more on the type of infractions that we're dealing with, and why, in fact, somebody who ultimately never pleads guilty, is never convicted of that crime, would still have a criminal record there. So would one of you like to come up and take a few questions from us?
Absolutely. Good afternoon, Representative Hasselfuss, members of the committee. My name is Matt Morgan. I'm the president of MACDL, the Maine Association of Criminal Defense Lawyers, and a practicing lawyer here in Augusta at McKee Morgan. I'm happy to answer questions or give maybe a brief background on the bill. This was not a sealing bill. It came out of a committee that did make recommendations for sealing, but this was not meant to be a sealing bill. It came out of that committee unanimously. It has MACDL's support as well as the Prosecutors Association's support, which is pretty rare when you see the two of us manage to agree on something. And the reason is that it's really meant to fix a problem with a bill and not change it. And the problem is just what Representative Hasselfuss indicated. The way a specific definition in the Criminal History Record Information Act is written and interpreted by the Attorney General's Office and State Bureau of Identification right now, makes it so that if a person were to be charged with a crime, and the example here is pretty much always the same, criminal speed, and a prosecutor says, well, I don't think this person needs a criminal conviction, I'm going to have them admit to a civil speeding ticket for a high fine, very common outcome. And a form is filled out where it indicates that the case has been dismissed because the person pled to another charge. Right now, the way the law is written, even though that person never was convicted of a crime, they will have a criminal record for the rest of their life that it was dismissed because the State Bureau of Identification believes that that's a part of a plea agreement. The reason that's an error and the error we're seeking to fix is that we don't plead guilty to civil infractions. We admit civil infractions in court. So that interpretation is inconsistent with the statute, and the easiest fix is to make it clear that if someone admits a civil violation and they haven't pled to anything. And that's the basic purpose behind 1918, really meant to be a clean fix to the statute. And I'm happy to answer questions if anyone has any.
Senator Searway?
Don't they already do that with deferred dispositions? I mean, you can just do, you can even admit as a criminal and just say, look, if you don't do this for the next year and you meet these certain things like paying the fine and maybe getting counseling, I don't know, but whatever they decide to do, that crime goes away.
So that's actually different. In that situation, Senator Searway, that person would be pleading guilty to something. That's the way deferred disposition works. They plead guilty up front. The scenario that this bill seeks to fix is when someone never pleads guilty. A prosecutor says this isn't a case where we need a conviction or even a plea. We're going to drop. And again, it's basically criminal speeding drop to civil speeding.
So the lawyer would tell you not to plead guilty. That's all. So I'm just saying that to me, you should get rid of deferred disposition and either do this or do the other, but not have all of them, because it seems like one way or another, you're going to be able to pick and choose whatever you're going to fit to make this work, so you don't ever get a criminal conviction. So I think it's wrong the way we're doing it here.
Yeah.
Because not showing accountability is really important.
Well, it's a
Right.
plea agreement, and those happen frequently. And
know.
certainly Shira Burns can speak for the Prosecutors Association, but
She did. She said, don't get rid of deferred disposition.
right. Well, no, they're in support of this bill, but deferreds usually require a lot more oversight. And for some defendants, that's not appropriate. And for some, the court and the DA's office don't want to spend those resources on people who have no record and who have a speeding ticket. So that's the difference.
Well, okay, thank you.
I don't see any further questions, but Mr. Morgan, I do have one other question. Can you just explain the difference between a plea, for instance, like in an OUI case where somebody pleads down from an OUI to driving to endanger versus, the criminal speeding case, or, like a Title 12 case where you plea from a crime that was charged to admitting a civil violation and never having a conviction in the first place?
Absolutely. So in the first instance, if there's no UI and it's being dropped down to a driving to endanger, that's a Class D crime being dropped down to a Class E crime. The only way you can be convicted of a crime is to plead guilty. So under the statute, the way it's written and the way it would still be followed if LD 1918 was passed, that person would have a criminal record because they pled guilty to first an OUI under a deferred. And then if they were successful at the end, they entered a plea to a driving to endanger, still a crime. If you have the criminal speeding situation, that person never enters a plea of guilty. So they admit a civil violation, which is a speeding ticket, and the criminal case is never a conviction. They've never pled guilty. So that's the primary difference. We admit civil violations, we plead guilty to criminal violations. As it's written, the statute is talking about a plea to a civil violation, which makes no sense. We're trying to fix that error.
Thank you, Mr. Morgan. Are there any, do you have a question?
No, Mr.
Representative
Chair, would
Milliken?
it be appropriate for me to make a motion at this time?
You can make a motion at any time, yes.
I'd like to make a motion of ought to pass. Is the language that we have in front of us good enough?
I do believe that there would be an amendment from, and I'm not getting the name of the agency correctly, but
I can at least get the acronym right.
Yeah.
DPFR, Department of Professional and Financial Regulation.
Yes.
I believe.
that they have an amendment that they would like to include in this, which their amendment speaks only to for licensing purposes, that they would be able to ascertain those criminal charges that would be technically confidential, but they will have access to them for their purposes of licensing.
And just to add to that, 1916 was a minority report, but DPFR's amendment was included in that. And 1917 was a majority report, and we included that as same amendment in 1916, just in case one of them fails, it's a backup. In the amendment that they handed out today, and I think was emailed yesterday, they had a very small change to striking one line in the sections that they already provided. So that's going to be a change that's going to, well, it'll come back for language review, of course, for the committee. But it's, in my mind, it's more technical. So sorry, that was a long-winded answer.
Thank
Than
you.
what you were looking for.
I'd like to make a motion of ought to pass with the amendment from DPFR
What if I told you I had one more thing?
and with one more thing. Drum roll.
From my memory, Julie Finn from the Judiciary Branch said with the integration, and the prosecutors might have more information on this. I think this technically requires something on their back end in terms of how things are logged. I believe they're asking for a date pushed back out to April 1st, 2027 for it to be effective.
And with that too.
Okay. I think that's it.
Is there a second of that motion? Senator Curry, are you seconding that motion? Okay, thank you. There's a motion and a second. Is there a question from Senator Searway?
On this, as it able to show, oh, thank you, Mr. Chair. Well, I was just wondering, is there any way that the statistic would even show if it was a drug driving and it got lowered down to, you know, to me, this is where we're gonna lose a lot of, not only, accountability, you're gonna have more drunk drivers on the road. You're gonna have also, funds, federal funds that you're gonna lose. So I
Senator-
was just wondering if the stats would show.
Yeah, Senator Searway. So to that, I think as Attorney Morgan expressed, the OUI cases are still criminal. Even if you plead to something else, you're going to get a criminal disposition at the end. And so perhaps there may be a ceiling bill or, you know, a ceiling ability to seal that. But we're dealing with ones where you were never convicted of a crime in the first place. So this bill does not address anybody who was convicted of a crime. So
But they would have normally before.
no, they would not have gone through the criminal process. And I, as Attorney Morgan just articulated there, if you're going from an OUI Class D to a driving to endanger Class E, it's still criminal. You have the criminal record. This bill would not apply to that situation at all.
That's not the way I understood it, but that's okay. I'll go along with that.
That would be my understanding as well. I mean, typically when this information is sealed, I mean, there's exemptions under the law about who has access to this information. And so, you know, under the bill analysis, we covered all those entities that would typically have access to this information. Since it wouldn't get to that point of it's not being, I mean, it was charged as a crime. So I would think internally that they would still have some sort of record, at least to that, in terms of like law enforcement have access to that. But in terms of the public record part, the point is that it's never getting to the point where it's considered a crime to be on a public history record. So for public records, they wouldn't have access to that. But internal certain organizations, I think, might still have access to the full record if this was originally charged as a crime, but it was pled down to something civil. So certain entities would have access to that still in the full history of the case.
Just a follow up on that.
Yes.
So we get, I don't know, it's quite a big sum of federal funds for OUI details or whatever. So if you've got somebody for OUI, do they lose that funding because it doesn't count as a statistic? That's what I'm saying, because and you could lose a lot of funds that way. It's because you'll never get an OUI from doing this, because you're gonna have choices of deferred disposition or this or whatever, and they're not gonna have the crime.
Well, so this has absolutely nothing to do with the final disposition of the case. This only has to do with who can see that record. And if it is somebody who can just search it online because it's public, or if it has to be a criminal justice agency. So it has nothing to do with the final disposition of an OUI case.
We find out for sure.
Ms. Burns, would you like to come up and answer that, please?
Shira Burns, Maine Prosecutors Association. Hearing that colloquy back and forth, I agree with Representative Hassenfuss. This bill is literally a clarity of when somebody is never convicted of a crime. This is, I know it was presented under the sealing bills, but this actually isn't nothing to do with sealing whatsoever. This is literally what happens right currently in law. If someone is found in violation of a civil violation, that is not public. With this caveat of what happened is if the defendant is charged with a charge that can change, pled down to a civil violation, which there isn't a civil OUI, that doesn't exist. But we do have a criminal speed, which was a great example because that's by far the most common that's done. It's charged as a criminal charge, criminal speed, but there's an agreement to do a traffic infraction on speeding. Right now, that criminal charge turns public because of the language used in the statute now. And this just clarifies that when a person is not convicted of a crime, and what happens is there's a civil adjudication, just a civil adjudication, that's it. That is confidential information and doesn't go publicly. No matter what, prosecutors will still see everything. We're going to always see the things. Law enforcement will always still see the things, but it will in no way affect OUI convictions or outcomes. This doesn't even give us another tool to use. All this is doing is clarifying who can the public see the adjudication of a civil violation.
Thank you, Ms. Burns. Representative Nutting.
Thank you, Mr. Chair. So in effect, this bill doesn't change the law or the criminality of it. It changes the people who can see the whole picture as opposed to parts of it. Is that true?
Correct.
So why are we calling this, why did somebody say this is not a sealing bill? Isn't that in fact what we're doing? We're sealing from view of certain people, not state agencies, not law enforcement officers, not professional regulators. We're sealing it from the public.
So, and when I use the word sealing, I'm talking about because we have a sealing statute in definition right now. So I'm using that. Sealing is about a conviction that then, even though they were convicted of the crime, the policymakers have decided that these crimes we don't want to show to the public after a defendant so many times, so many years have passed. That is not what this bill is doing. There's not a sealing because there's nothing that you're not going through the sealing process. Policy, your past legislators have already made the policy decision that civil adjudications are not something that our SBI gives out to the public. So per the statute, those are confidential already. Now that's a policy that has been already decided by this legislature. This just gives us clarity regarding that policy that's already been decided, that civil dispositions, civil adjudications, after the process we're talking about where there was a criminal charge that was dismissed, but there was a civil adjudication, that should fall under the same policy that was already decided, that that's not something that's public.
I understand. Thank you. That's sort of clear. Technically speaking, it's not sealing because it's not revealing, it's not sealing. But I think to the common person on the street, it is a distinction without a difference. So thank you.
Just commenting on that, I view a criminal record as somebody who's been convicted of a crime. An arrest record may be different, but I don't think arrest records are public. I think it's only the criminal records that are public, and the crux of that is where you convicted. And in all of these cases, by default, they were not convicted of a crime. And so that's why I feel that it's different, but
Just I'll follow up on that, what you just said. Okay. Thank you, Mr. Chair. Just a comment on what you just said. My question is, okay, you're a school and you're hiring a bus driver and he went over 30 miles per hour at criminal speed, and you're hiring and it got lowered down and now it doesn't show that he did criminal work. and you're putting the kids in danger now because this guy's a reckless driver. How does that work? I mean, to me, this is where, before you had to tell what you did. There's accountability, and that way you know who you're getting and they own up to things. But now you're just trying to cover everything up. And so that person doesn't really have to show accountability. And that's what I'm getting at. So I just cannot go at and say this is a good bill because it just does not fit for the public. So.
Bernice, I think we're ready to vote.
What did she say? Right. LD 1918, the motion is ought to pass as amended by Representative Milliken, seconded by Senator Curry. Representative Hassenfuss.
Yes, ought to pass as amended.
Representative Hassenfuss says yes. Representative Nutting.
No.
Representative Nutting says no. Senator Searway.
No.
Senator Searway says no. Representative Lookner.
Yes.
Representative Lookner says yes. Representative Abdi is absent. Representative Perkins.
No.
Representative Perkins says no. Representative McIntyre.
No, thank you.
Representative McIntyre says no. Representative Ardell.
Nay.
Representative Ardell says nay. Representative Bunker.
Yes.
Representative Bunker says yes. Representative LaJoy.
Yes.
Representative LaJoy says yes. Representative Milliken.
Yes, please.
Representative Milliken says yes, please. Senator Curry.
Yes.
Senator Curry says yes. And Senator Beebe Center is absent, so we have 6 in favor of the motion, 5 opposed and 2 absent. And those of you opposed to the motion ought not to pass, all of you. Okay, thank you.
Okay, thank you. Thank you, Bernice. And Will, did I say that the next one we're going to take up is
County jail funding.
county jail funding? Okay. All right. Okay, we'll open the work session on 2232. Will, do you have any thoughts for us on this?
Yeah. If I could just go through, I think first just kind of explaining some of the changes that were made from the report we got. As you'll recall from Tim's testimony, this was based off of Appendix A from the Professional Standing Council's report. But there were a few changes that needed to be made to it. Some I think are technical and less problematic, and some I think probably need some clarification to make sure that we understood correctly and drafted it in the way that it was. First, if you've got the bill next to you, I'm just going to be going through some of the lines to compare to the report. Emergency preamble is fairly straightforward. That was the technical part. The money would be appropriated prior to July 1st, 2026. So that was necessary. I don't think that's too controversial. Lines 18 through 20. So as we've discussed, the bill increases the statutory funding amount by $8 million beginning July 1st, 2026. And then this is current statute plus any additional amount the legislature may appropriate. So obviously up to the legislature to provide additional money on top of that statutory amount. The initial language from that appendix, from that report, just stated that this amount will be adjusted annually by 4%. And that immediately follows that language of plus any additional amount the legislature may appropriate. So we did make a small change there that the amount required to be appropriated under the subsection must be increased annually by 4%. So that was the idea of, you have this $28 million figure, and if there were additional requests came forward from the county jails or whoever it may be, that they were requesting more money, that was that 4% based off of just that baseline $28 million that's in statute? Was it meant to include the new appropriations that might have been one time or however it might have been? So that language was changed just so that it's specific to that 4% is that $28 million figure. I think that's the intention, but if that's not, if that creates any problems, feel free to speak up on that.
That's a good question.
Senator Seaway?
On the 4%, I thought that was only up to 4%. That 4% was like a cap. So it says annually by 4%.
Yes, I think that's partially mixing up the county's mechanisms for increasing funding. So it would be by 4%. The original language that was provided to us was not up to 4%, so it would be 4% every year.
Okay.
And you might take issue with that. Certainly a point for discussion. And then just one other portion, I can stop there though.
Yeah, Senator Curry.
Can you address, and we have no ability to dictate the actions of a future legislature. And so how does that work? I mean, is this similar to the referendum, say you will do it at 55% and hope the future for school funding and hope the future legislature sees that and goes, we're morally obligated? Is that the hope?
You might have to restate that for me. Are you asking, is
So
this,
we
is this
can't-
binding the hands of future
Yeah, we're not
legislators by
binding,
having the 4%?
yeah, we're not binding the hands. We're saying we're binding the hands, but we can't bind the hands of a future legislature. Yeah, we'll not tell them. That's, so I guess, so it's a statement. Is that the net effect? It's a statement of our intention.
Yeah.
That, okay.
Yeah.
That's fine.
Yeah.
I think that's what all laws are.
Yeah. And then so just one other change to kind of a large change, obviously, in section 2 of the bill regarding community corrections and those funds used for those programs. So the original bill was quite a bit more simple. It just said $5 million will be provided annually to community corrections and programs and services. In that language, they did strike out must be used by the county and jails for those purposes. So we added language that the funds appropriated pursuant to the subsection may be used by the county jails and regional jail for establishing those community corrections services, whereas right now it's 25% of that allocated amount must be used for that. Again, I believe that is the plain intention based on the report, since they did strike out that language must be used for those services. And I think that the language in the bill leaves that $5 million amount entirely up to the county jails as to how they use those. So again, I believe that was the intent based off of the report, but that's how it would operate if this was passed.
Representative Perkins.
Thank you, Mr. Chairman. Just maybe a comment, a little food for thought. And last 5 years, from 21 to 25, the CPI was 7%, 6.5%, then 3.4, 2.9, and 3%. So it fluctuated each year, which shows that our economy changes each year. So rather than having maybe set a set number of 4%, maybe tying that increase to something like the CPI, where it would increase more on years where it made more sense, and having it a little bit less on years where it made more sense, so that the state wasn't spending as much money as it need to, might be something to consider.
Representative McIntyre.
Thank you, Mr. Chair. In line with the comment from Mr. Perkins, I've been sitting here listening carefully, and a lot of numbers have been thrown around. I view the 28 million as a Band-Aid, and I think we need to be looking at long-term fix like surgery. And I believe what we've come upon is a structural issue, a structural funding issue. And so in line with that, unless there's further discussion that's needed, I'm prepared to make a motion. Okay, I can defer.
So I have a question for you, Will, sort of on what you were just talking about. And this $5 million.
Mhm.
I read that as being an additional 5 million over the 28 million.
Correct. I would agree with that.
Which as Senator Curry pointed out, I think was the 84% increase or something like that. But so I just want to make the committee aware of that too. And currently that 5 million was essentially just a 25% of the 20. So that's drastically different from just jumping from 20 to 28, because that we also got to consider that additional 5 in there. Senator Curry.
Thank you. I'm kind of reacting to, I did not catch that the 5 million was a May. And so I really want to have a bill that we can be, that's not just a symbolic bill. Hey, we voted for counties. We actually get something across AFA. But I struggle with that, to say we currently are requiring counties to do community corrections. And this bill, as my read, it says, hey, do community corrections if you want to, otherwise use the money to not do it. And I would have a hard time voting for that. I'd love for us to have a very strong report from all of us, but I can't do the May option on the community corrections.
And just to point to that as well, it is odd because the way it's basically drafted is you have some odd language about these funds, may be used by the county jails and regional jails for establishing, providing, and maintaining a community corrections and program services, which is required by section 1208B. So you kind of have some of this weird juxtaposition of like required by this section, but here's some funds that you may use for it. So it's like they have some obligation there still under statute. So part of that money, they're going to have to do it pursuant to the statute, but it's not that entire $5 million. So I think the intention, it was maybe addressed briefly today, was to provide some form of flexibility. It's whether that level of flexibility is something that the committee is comfortable with as drafted.
I do. Yeah, we'll go to Representative Lookner.
Thanks, Mr. Chair. I still feel like I need some info on this, and I really realize we've reached the point of that time in the session where we've this artificially imposed statutory adjournment, because everybody knows problems in Maine stop after April 21st. So we're adhering to that, or whenever statutory adjournment is. But I feel 15. Thank you. And I feel like I still need more info. Like I didn't get the question answered about like where numbers were at in 2018 and 2019. And I still there was another question I wanted to ask about. I want to get a fuller picture about how ARPA funds were spent by the counties and where we're at with all of that. So really think I need to get a fuller picture here before I decide what direction to go. And I realize we don't necessarily have the luxury of time, but if we did, and we're being good studious legislators, that's what I would ask for, is more time.
So what I was going to ask is, what does the committee feel about section 2, paragraph 3 there, where it's this additional 5,000, but it's I think 5 million. Senator Curry already mentioned that May is problematic. I tend to agree. The May is problematic. And it's also $5 million over the $8 million ask. So I think that's, and if we're looking for AFA to actually do something, I'm not sure that adding that paragraph in there is going to be overly helpful. I see the confusion, Representative.
So are you suggesting striking that section or changing the word may to must?
Well, I'm thinking 2 possibilities. One, a shall or a must. The other possibility, just striking that section and keeping it at 8 million and not, the 8 plus the 5.
Concord.
Yeah.
Mr. Chair, I request a 5-minute caucus.
Before we do that, are there other questions on the other pieces? Are there any other questions on this bill? I do think another important piece is what we want to do with the 4%. Do we want to tie that to, you know, the CPI or do something else with that? Representative Perkins?
Mr. Chair, I put that out as a point of discussion as an example. It doesn't necessarily have to be tied to the CPI. I'm just saying that there's some years that I don't think 4% is going to be necessarily, like I say, back in 2021, CPI was 7%. And I just don't know if 4% is actually going to be sufficient every year. I think there should be, whether it's the CPI or something else, there should be some kind of measure year for year that we look at to say, hey, we need to make sure that there's an increase each year, but that it's tied to something meaningful so that we can make sure that jails get adequate funding. But CPI could be one of those things.
Representative Nutting?
Thank you. I tend to like the CPI because it gives you something that you can look at that you didn't cause. It wasn't arbitrary. Somebody's figured it out, and it's used in municipal government for to figure out raises for employees, for instance. Very helpful when you offer your employees this year. I think it was a little less than 3. I think if they want a lot more than 3, it's easy to kind of guide you to some number that somebody else has figured out, not us. Before we take our 5-minute break, can somebody explain to me again the 5 million and where that came from? Because I don't recall seeing it. Mr. Curtis, perhaps. In all the discussions we've had previously, I understood that the percentage, the 20% actually went away in the last 4 or 5 years, hasn't kept up. It's 15, give or take a point now. But the 5 million comes as a new, it must have been in the report, which I read the executive summary probably, and I missed that part. So explain the ask for the 5 million one more time.
Yeah, and let me say, I apologize for the confusion. I appreciate the edits that you've made, and we're in agreement with those edits. The 5 million came from essentially what the 25% in statute is now. The way the statute reads under Section 2, Item 3, at least 25% of all funding provided will be used for community corrections. So that's the way the statute reads right now. So of that 20 million that's in statute, 5 million, when the money comes to the county, we take 25% of what comes to the county and we put aside to fund community corrections. It's been the position of the Standards Council to move away from that, to either eliminate the language of the 25% or to set aside additional funds if the state wants to fund the county's community corrections programs. One of the things that the Standards Council will have to do in the future, near future, is redefine community corrections, because so much effort has been going on since that was put in statute in regards to mental health and MAT, that's really handcuffed the county if we have to set aside 25% of the money we receive for those things. So I think we would be in favor of striking paragraph 3 altogether. We would be in favor of striking the 25% requirement and taking the $5 million off of the table. Again, our focus is to get that baseline up to 28 million or more. But I see where this community corrections additional 5 million is causing confusion. And to Representative Hassenfuss's point, any confusion we need to eliminate before we get to the appropriations table. So we'd be in favor of striking that altogether, or at least striking the 25% requirement.
Thank you.
Are there any other questions? I don't see any.
I'll take 5.
Okay. All right, welcome back, everybody. I think we're ready. Representative McIntyre, did you have a motion that you were prepared to make?
Thank you, Mr. Chair. I'll give this a whirl. I would make a motion of ought to pass with the following amendments. Raising the $28,342,104 to a baseline of $30 million. Adding in, instead of the 4% annual escalator, tying in CPI and striking in entirety, section 2, paragraph 3.
Representative Perkins?
I will second that.
And there's been a motion and seconded. See, you have a question, Will?
Yeah, so for the section 2, subsection 3 there, are we saying we're just striking this from the bill, or are you seeking to repeal the actual underlying section of law? Repeal the section of law, so there's no more than 25% tie to the.
On Mike, correct.
Okay.
I will just say that I will not support the complete repeal of that. What I would support is just leaving it alone.
Strike the
like,
section from what you're saying. would be
from
more
the
for-
amendment. So
that
like
would be
current
repeal.
law stays exactly as it is,
Yeah,
but the 30 million is there.
okay.
So there may have been a misunderstanding there. Representative Senator Curry.
So I'd ask if Representative McIntyre would consider a friendly amendment to keep so I'm uncomfortable with losing the 25% requirement around community corrections, that becomes a may. I would love to be on support of a strong report here that we continue the 25% requirement. We haven't dealt with that side of it. I get that there is more work to do in redefining community corrections, but dropping the requirement for community corrections concerns me that we haven't had a proper discernment, a proper process for doing that. So if I'm all for raising it, but I don't want to touch the 25% at this point.
Representative McIntyre.
Mr. Chair, in response, I would say I would accept that.
So the motion, thank you, Will, for clarifying that. So the motion would be, the only laws that we're going to change would be section 1, paragraph 2. Everything else is going to stay as is currently written in statute.
Okay.
Did you have a? But sorry, yeah, by everything else, I mean just section 2, paragraph 3 stays the same. Yeah.
And then the $30 million, so that's 30,342,104, or you're just asking flat 30 million? Flat 30 million, okay.
Representative Perkins.
Thank you, Mr. Chair. I have a question for Will. And then if that's the case, if that section 3 stays at that 25%, we raise that to 30 million, would that requirement for community corrections then go up to 7.5 million?
If it's a must, yes. If it's a may.
Instead of the 5 million that it is now? Because it would be
Yes.
25%
I mean, yes,
of that
it'd
30
be
million.
attached to 30 million, so whatever 25% of 30 million is, if that's 7.5, yes, you'd
So-
be.
1%.
Yeah.
We're actually then handicapping them by 500,000 because we raise it 2 million, but then you're requiring 25%. So instead of 5, you're giving them an extra 2.5. So you're actually handicapping 500,000.
Senator Curry.
I think that the dilemma, if we change the percentage, once AFA does something with it, it's going to change. So if they cut it down to, if they put it back to 28, we're at 20, we've added 8 million under the current standards. We've added 8 million. If they bring it back down to 28, if they cut it, I think it's going to be hard for us to figure out, given that AFA could just say, we're adding 5 million, we're adding 7 million. I hope we get the full 10 million. That's the dilemma that we have in this.
We have Sheriff Joyce.
Do you have a question?
Please get a little.
Do you have a question for me, Senator Cyril?
Well, yeah, I do. I do.
Okay. Must have looked on the wrong way.
Yes, sir.
Thank you, Mr. Chair. So I was talking to Sheriff Joe Mary, and he had said that the 5 million was not a big time breaker. Now we're talking about the 25%, and that's basically what the 5 billion was, right? Is that what we're talking about? And
Under current funding.
yeah. So how's that work if we bring it up to 30 million and then keep it to 25? We're actually adding up to 75.
Okay.
Right? 7.5, right?
Well, I think that, I don't know if there's a way to do the 30 and then the percentage is gonna make it the 75, so.
Yeah.
Or 7.5, so. There are a lot of other things that we need the money for now outside of community corrections.
Right.
As was mentioned earlier, MAT and some of the other mandates that were
Right.
were kept with, rising costs of utilities, et cetera. So I see where you're at.
Yeah.
25% causes everything to go up. And
Yeah.
I think we need it in the other part of the budget, just in the funding.
That's what I
Excluded.
understood it as. Yeah. Well, thank you. That's what I was asked.
Representative Perkins, I'll get you next.
So as to your amendment question, or would you be agreeable to, instead of 25%, changing that to 17%? Could still be 100,000 more than that flat 5 million, but would handicap from the price increase. So it'd still give them more overall and an extra $100,000 towards the community corrections without taking that all out.
You could maybe also adjust that number to CPI too, but Representative Nunny, you got a question?
Well, just that originally we were looking for 28.3 million. Now we bumped that up to 30, but we've changed the 5 million to 25%. So we're actually going back below the 28.3. We're down to 20. I don't have the real numbers, but we're down in the 26, 27 million range now by doing that. We're adding some on, but we're taking more away. So we've just hurt ourselves.
All right, Senator.
I mean, so our real starting point is 15.4. Our starting point right now, what we're paying is 15.4 for jail operations because 5 million is going over to community corrections. And so if we're at 30 million and 7.5 is going over to community corrections. So 30 million minus 7.5, oh, I'm doing math on Mike. What is that?
22.5.
22.5. We've just raised 7.5 million specifically for jails. I'm just kind of trying to make sure I know where we are in all this. And I know the jails are needing this. We haven't talked at all about community corrections at this point. So I'm trying to do no harm on the community correction side of things. So just thinking.
Are you
put pressure on me?
Yeah, no.
I would be, I mean,
Senator Kerry, yeah.
I mean, on Mike, I would, I'm like, what is 20% at that point? If we're at 30 million and 20% of the 20% of that dedicated must be dedicated to community corrections.
6.
Yes, 6. It's 1/5.
Yeah, I don't know where my colleagues are on that, but
I can speak for myself. I'm trying to figure like if we did a number that has to go, like say 5 million has to go to community corrections adjusted by the CPI. The problem is, how do we know what percentage of that each individual jail would get? So I'm not sure how we could actually set a number and keep it at the starting point of 5 million and set the number that way. So I do think you probably have to do some sort of percentage. I would think, and I think you could lower the percentage a little bit. But at the same time, like, they're getting more for their operating costs, so they can offer more for, community corrections costs, right? So just do it at a 3-to-1 ratio. That's what we're asking.
Mhm. And have the language be something to the effect of at least 20% needs to go towards community corrections, which is probably what it is right now. What does that get for jail functions?
Well, 30, it'd be 24, right? If we're taking 6 million off, sorry. If we're taking 6 million off the top by 20% and we're starting at 30, that's less than they need.
Representative.
Senator,
But 24, but we're coming up from 15.4. Right? Because right now, for jail operations, not community corrections, we're at 15.4 from the state. And we're recommending going up to 24.
Instead of.
Yeah, sorry.
You're saying instead of the 28,342,000? Okay, hold on a second. I'm trying to follow this. Raise it to 30 million and you're saying commit 20%? And then both of them have a CPI adder, both sections going forward, or just? No, you're saying take 20% out of 30 million plus CPI going forward, 20%.
Senator Seaway.
Can I have Solon, will it come up?
Do you have a question? Yeah, if you have a
Yeah,
question for
yeah,
him, you certainly
yeah.
can. Yeah.
Can you come up, Solon?
Just
Yeah.
as we're awaiting that, if I'm struggling to see if we bump it up to 30 million, we're increasing the total amount that the jailers are going to receive. Yes, we're increasing the amount that they have to spend on community corrections services, but we're also increasing the total amount elsewhere. So I'm not sure they're going to get less money. They're going to get more money, but they're going to also get more money in another area that they can't, divert and go there. But they're not getting less by any stretch.
Right.
They just might not be able to use it exactly how they want to.
So.
Yeah, Senator.
So, thank you, Mr. Chair, and I kind of with you on that, but I was just gonna ask Solon, because he's been in approach for a long time. And also that, you've been in county corrections, commissioner. So I'm trying to figure this out too. We was kind of set on 30 million and as a set and with a CPI and scratch this 5 million out. Do you think that is probably a more practical way to go than it is to add this 25% or the 75 million and then take away from the other? How do you feel about this whole, how that works?
At this point, for 4:40 on a Wednesday night, you are my favorite policy committee ever. And I want to make that clear because you have endorsed 3 of the issues that are most important to the county government. You've endorsed the need for a higher baseline.
Right.
You've endorsed the need for more money in the current biennium, and you've acknowledged the need for an inflator going forward. I think those 3 things are the 3 things that are most important to the counties. We have a 20% provision set by Governor Mills in 2019, but never codified in law. So really, and I call that a sin of omission. We thought we heard it clearly. We thought we heard it as legislative intent. It was said in testimony, but it never got in law. So that part of the past, I think, is behind us. What we need now in this biennium, you helped us getting 4 million in fiscal 26. We need certainly more in fiscal 27 because we're going backward. We need that 27 year to become a baseline going forward. And Representative Hassan, I know you're getting this. And I heard you talk about the 28 million in the draft in section 2 or section 1, part 2 as a cap, but it's really a baseline. It's a stepping off point for the next governor, the next biennial budget. And so it's important that those three things that you have already verbally endorsed tonight are part of a final solution. If you can stay with those three, this 5 million and what percent, if it were administered in the current language law, with the must be, it would be hard to say that the total needs of the jail population are being met by a hard mandate on 5 million at 25% or 25% of 30. And that's not to say that community corrections isn't important. I think that's been part of the language in the correctional world for the last 20 years. It also is important to understand that we do a lot of mandates that have been posed since then, mental health, math, and other things. So I wouldn't want to get us all too hung up, but if you could reduce the percentage and give us more flexibility, Senator, in utilizing that stepping off point from 30 going forward, it gives us the flexibility to plan. Every county is unique. Every county is different. Community corrections is important, maybe for all of us to keep in the law. But I'd like to get rid of that must be at 25%, because that ties the hands of jails that are experiencing totally different issues in just trying to keep the shop and the jails open.
Thank you.
Will, do you know when that 25% language was put in? Was that to 2020? Do we know?
I think that was a bill that was referred to as the Jail Operations Fund statute enacted in 2021, and it's referred to in the professional standards report. I think that the author of that bill was the former representative from Hollowell, and she may have sat on this committee in the past. And it was a negotiated one. Sheriff Mary actually has some knowledge, as do other sheriffs and administrators. But I think that whole statute that we're looking at, look at the bill that Will is saying, it all ties to Public Law 2021, Chapter 732, enacted in the spring of 21, the 130th, and it included all of these sections of law, which was a step beyond the verbal 20%, which never got codified. 2 years later, we have this statute, which is the Jail Operations Fund statute. And I don't have that full history because I think it emanated from this committee. I think Charlotte was the sponsor of the bill. I don't remember it getting a lot of debate for those of you who are still in the House and Senate.
Representative Mill, let me ask you this, and you heard my comment before, is if we kept the law as far as section 2, paragraph 3 the same, so that 25% of all state funds needed to go to the community-based services, the jails would still be getting 3/4 of that increase. Why would that not still be able to satisfy the needs where they're getting a 3/4 increase to address whatever they want to address, and they're getting a 1/4 increase on stuff that perhaps they don't have an immediate dire need for, but they could improve? And so we're, if the legislature was saying, we're going to give you 3/4 for all your other stuff, 1/4 for this, so you can, use this other money on your new boiler or what have you. But you can't use the whole thing. 25% of that, you got to expand services or improve services in this area. Would that be unworkable?
I don't think unworkable. And to my earlier comments, Representative, If you do the three things that I spoke of and you choose to just eliminate section 2, paragraph 3 from the report out, and you give us 30 million at a CPI level going forward with the escalator language tied to CPI, great progress. If it was my intent of raising the question, if the 25% could be reduced somewhat, it would give us more discretion at the county level. Maybe not every county needs to put 25% of what you give us into the community corrections as defined. Maybe some do, maybe some don't. So I was just urging that maybe there'd be a little attention to reducing that. But to your open question, we take what you just described as a step in the right direction.
Representative Perkins.
Thank you, Mr. Chairman. I think that just instead of giving, I'm just making a comment about some of the comments I've heard. 3/4 of what they need is still only 3/4 of what they need. I think we're trying to fix a structural problem within the jail funding. I think we need to give them what they need. And as far as this other quarter being about something to fund what they want, I don't believe that any county commissioner or any sheriff in front of us today or spoken to us or given this testimony is coming here about something they want. I believe that everything they're asking for is because it's something they need, whether it's community corrections, whether it's Matt, everything they're coming to us for is a program that they have in their jail that they need. And I believe with Commissioner, former Representative, that every jail is unique. If you walk into Piscataquis County Jail and then go walk into Penobscot County Jail or go walk into Cumberland County Jail, you will have three very unique experiences because all those jails are different. I've been in all those jails, but every jail's run different. Every jail has a different population, and they all have unique needs. And so to say, we as the legislature are so smart that we're going to demand that you spend 25% of this money on this one program without knowing what the specific needs of that jail is and not listening to the people that actually administer these jails. I don't think that's the wisest choice that we should make. So I completely understand that maybe looking at it and saying, hey, if we get rid of this requirement that you have to spend 25% of the money on community corrections may sound like community corrections is going to go away. But I will bet my bottom dollar that there is no sheriff in this room that is going to get rid of any community corrections program that is working in their facility simply because we take that language out of statute.
Representative Bunger.
I would agree with Representative Perkins. I don't have any concern about community corrections going away from any jail or any sheriff themselves. I would like to see them given their flexibility, knowing their terms are unique and different in that. And in previous testimony, somebody mentioned going forward, the definition of what we all mean by community corrections needs greater clarification for folks to be able to understand and quantify it. So I'm okay setting aside that particular language and going for the early goals that were mentioned.
Senator Curry, unless Will should proceed that.
That's okay.
I'm curious if the sponsor in the second would consider a friendly amendment to go to 20% on the community corrections and unallocated language to, and I might need help with this, for a body to answer that question of defining community corrections and and examining it and coming back with a recommendation for the 133rd about what is included. I'm just thinking that this is work we need to do, and it's not going to happen at 4:50 on the last day of committee work. So I'm wondering about both. If you don't want to include the second part of that, I'm fine. But if you want to, it might be a way to move forward.
Will?
So I think it's relevant to this and what Representative Perkins said, and I'm going to paraphrase, but that they wouldn't be getting rid of community corrections programs. I think that's true because under the statute, I mean, they're still required to do it. It's talking about what that money must be used for versus what they are required to do generally, not looking at the money. So 1208B subsection 4D is each jail shall provide community programs and services as required by the subchapter, including at a minimum pretrial or conditional release, alternative sentencing or housing programs, and electric monitoring. So it doesn't fully answer the question of what everything is included in community corrections, but I think it's correct that it's not going to go away because it's still required by statutes. And I think the Department of Corrections operating procedures, it's probably detailed more at length in that, which I don't have in front of me. So I think that's correct. It's just how much money goes towards those things versus it's not a question of they will or won't do it. My understanding is that they do have to do it under law. It's just how much money goes towards it, if that helps.
What if we, so I see the baseline currently sort of being 24.4 million. I know that fiscal year 27 hasn't been allocated that, but I expect that we probably can get the 24.4 million from AFA. So I kind of view that as our current baseline. So what if we took 25% of, let's say 25 million, because I know it's not perfect, but it's close there. So 25% of 25 million, and that's what we know the jails are currently using state funding for the community-based services on. Have that be the baseline. And so you can use your percentage to make sure that whatever percentage that's in section 3 down here is 25% of 25 million. And then that could be the new percentage. So essentially we'd be keeping what the jails are currently getting that is specifically allocated to community-based services, that they would take that money and then that percentage would then increase based on the CPI for the full percentage. So we're going to drop that percentage down to whatever the actual funding source is now. Does everybody follow that?
You lost me on that one.
Or am I not?
I not at all.
Okay. Okay, let me try to.
I need a whiteboard.
Yeah. Let me try to explain that. We take the current percentage that all the jails are required under the current law to pay.
25%.
Set, yes, of 24.4 million is what they got in fiscal year 26. Take that number, that actual amount, and then take 30 million, figure out what 30 million divided by or multiplied by is that same number, and that will give us our percentage. And then that percentage is the percentage that we can put in the statute. That would then go up by the CPI. Okay. Representative Perkins.
Thank you, Mr. Chairman. And I know I seconded the motion, Representative Turner offered the motion, but having listened to the good senator's friendly amendment offer of 20% and haven't seen the nod from the sheriffs that would probably be very workable for them. I think that and having also heard the comments from other members on the committee, I think that would be acceptable to us and we would be very agreeable to that. So basically the 30 million baseline tied with the increase tied to CPI and then 20% tied to community corrections programs. We would be very agreeable to that, Senator.
With unallocated language to be determined.
Yeah.
To achieve what outcome?
Senator Curry.
I think and I don't know who to ask to do this work, which was to come back to have a work group to determine what is included in today in community corrections. What are all the different things that are included in this? And I mean, what I was hearing was we needed definitions, and to make definitions of what is community corrections today. And maybe that's just one person's comment that said we didn't have good definitions, but that was the only thing I was thinking is like to come back and to help move the ball forward on that.
What about that same group that did the original report? And that would also include the financial piece, but Representative Perkins.
I was just gonna say, I was wondering if maybe we could find out at language review if maybe our analysts could actually find out if there are actual good direct definitions of that before we cite
Yeah.
that. But I'm not.
I'm fine on language
Senator.
review. If that's, you know, not needed, then we don't do it.
Yeah, I think I'm agreeable with that, Senator.
Representative Bunker.
I think on these greater issues, we already have a standing commission that would do a great job and probably accept that challenge to come back to us. It's all the right stakeholders.
I do actually, I think.
Okay, Bernice, I think we're ready yeah, Representative Milliken.
Thank you, Mr. Chair. I'm probably unsurprisingly gonna vote ought not to pass, just so everyone knows. And I just want to just say I happily support, well, kind of begrudgingly actually, supported the budgetary request of 4 million or 8 million, what did we say? When we submitted our report to AFA, in part because I understand the jails need an immediate help, support. I don't plan on making a stink of this one on the floor. But I think it's important. We got a bill referred to us today to look at how we can reduce costs of the county jails. I think that's an important thing that we need to be seriously considering and looking at alternatives to putting people in jail and having better outcomes. So anyways, I just wanted to make a quick statement before I vote no. Y'all did a good job debating that one, though. That was great.
I think we're ready, Bernice.
For LD 2232, the motion is ought to pass as amended by Representative McIntyre, seconded by Representative Perkins. Representative Hassenfuss.
Yes, ought to pass as amended.
Representative Hassenfuss says yes. Representative Nutting.
Yes.
Representative Nutting says yes. Senator Searway.
Yes.
Senator Searway says yes. Representative Lookner is absent. Representative Abdi is absent. Representative Perkins.
Aye.
Representative Perkins says aye. Representative McIntyre.
Yes.
Representative McIntyre says yes. Representative Ardell.
Yes.
Representative Ardell says yes. Representative Bunker.
Yes.
Representative Bunker says yes. Representative LaJoy.
Yes.
Representative LaJoy says yes. Representative Milliken.
No.
Representative Milliken says no. Senator Curry.
Yes, thank you.
Senator Curry says yes, and Senator Beebe Center is absent. So we have 9 for the motion of ought to pass as amended, 1 ought not to pass, and 3 absent. Thank you.
Well, then that was supposed to be the second quickest one. I might have failed on my predictions.
We might be here a long
No, I'm hoping that I was wrong, and if the committee could appease me on that and get straight to the point.
It's 2058 next.
2058 is next, yes. So next we will open the work session on LD 2058, which will, I believe that we have an amendment that all of the committee has received and that you've circulated.
Yes, I can proceed. I think Bernice might have had directions to get Senator Talbot Ross when we were beginning this, but okay. I can just begin on the bill analysis if that's okay, unless you were intending to wait for the sponsor.
No, I think that's fine as long as you have the bill analysis. That is specifically for the amendment
It
that
is.
was sent out.
It is, yeah. So that was distributed in a separate handout, and I did include that language in the bill analysis as well. So as you can see there, the language was a bit broad, as some people had mentioned in the public hearing. So that has been really tuned down to target a specific instance here. So now reads, municipal and county jails shall at all times be available for detention of persons arrested by state or any other law enforcement officers unless the persons are detained solely for a civil immigration violation. So before we were trying to sort out which officers, is it state, who is it? What type of, was it on state criminal charges? So I think this probably very much narrows in on what we're specifically looking at and kind of peels back some of that original language as to who that would apply to, or at least some of the concerns from interested parties. So I will say, I just reading it, it was reminiscent of LD 1971, which I don't think we need a long legislative history on, since that was a bill that you all considered in the first regular session. As you may know, that bill was passed in both chambers. It was held by the governor, but it was not vetoed. So it has become law without the governor's signature, but won't take effect until 90 days after the legislature adjourns. So that newly enacted section of law under Title V, Section 4763, and a copy of that bill is attached to the bill analysis. It details certain activities that a law enforcement agency generally may not conduct. Most relevant to the committee's current deliberation is the following prohibition. A law enforcement agency may not, except as provided in subsection 2, use agency or department money or personnel to investigate, interrogate, detain, detect, stop, arrest, or search a person for immigration enforcement purposes, including detaining a person solely on the basis of a hold request. So that's just part of that statute. If you look to the attachment at the bottom of page 2, that lists out prohibited activities in more detail. But there was a lot of things from that bill that created some restrictions and limitation between state law enforcement and immigration officials. The amended law language to LD 2058 states that municipal and county jails, as we've discussed before, shall at all times be available for detention of persons arrested by a state or any other law enforcement officers, unless the persons are detained solely for a civil immigration violation. For my interpretation, the change doesn't appear to be a particularly substantive change to law, given the sweeping changes that have already been made under LD 1971, which contains the vast majority of the operative law regarding how state law enforcement officers work and interact with federal immigration authorities, such as whether law enforcement agencies can inquire into a person's immigration status, or perform functions of an immigration authority. Instead, the language generally appears to more closely align with the new state law prohibiting detention of a person for immigration enforcement purposes. Additionally, the new language appears to address concerns related to how the original bill could have inadvertently impacted certain federal enforcement agencies, might have been the U.S. Marshal Service or the Drug Enforcement Administration. Likewise, the amendment appears to address Department of Corrections concerns regarding how the original bill could potentially prevent jails from holding individuals who have violated their probation, as the original bill specifically stated the jails shall be available for detention at all times for persons arrested on criminal charges. DOC additionally held concerns regarding the original bill, which would absolve county jails from holding anyone found incompetent to stand trial or not criminally responsible, which would push these individuals into facilities that are at capacity. I believe that's addressed too with the amendment. Of course, we'll defer to the Department of Corrections if they still have issues with the language. But since it is a lot more specifically targeting those that are detained solely for a civil immigration violation, it's not readily apparent that that would be an issue anymore. So all of that is to say, this provision of law in Title 25, I feel like we got a nice history from the ACLU and the sponsor regarding where this came from in 1964. But ultimately with 1971, as I said, that contained a lot of the operative language about how state law enforcement agencies interact with federal immigration authorities. So to me, this feels like just a slight extension to 1971, perhaps something that should have originally been addressed in that bill. Because to me, you might not agree with the underlying policy, but I think that this change probably more closely aligns with what the state law is, given the passage of that bill. That's my interpretation of it. I'm not an immigration expert. I believe this is our first immigration bill, which would typically go to judiciary, but I guess we're sharing the topic sometimes now and we have some overlap. So that's all the information that I have. I'm happy to try to answer any questions.
Thank you. Thank you, Will. Thank you for this. Sheriff Joyce, I know that you've been working through this amendment with a number of individuals. Do you mind coming up for a second? Thank you, Sheriff. And can you're in your jail, you house some individuals for the U.S. Marshal's office. Isn't that right?
Yes.
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 And you've had that contract since like the 90s?
33 years.
33 years. Do you think anything in this amendment, or are you comfortable that this amendment won't, jeopardize any of that?
Yes.
And you're comfortable that any issues that you may have had with the original legislation has been worked out here?
Yes. We weren't holding the administrative civil violations of ICE before they pulled their people at the end of January. They were all the worst of the worst. About a third of them from the state of Maine. The other 2/3 were from New England for ICE. And it was about anywhere from 50 to 70 inmates. So this allows us to continue what we were doing if ICE decides they want to house their people back at our jail. It helps the previous issue about funding jails because, like it or not, our jail 33 years ago was built on federal revenue. It's not a new idea. I can't take credit for it. So I'm confident that this, as written, takes care of some of the issues that Senator Talbot Ross's folks have brought to her attention, but it also allows us to maintain public safety, assist ICE and the U.S. Marshals. The U.S. Marshals won't change. And I think everybody wins.
Yeah. And so I remember there was some discussion over, civil cases and whatnot. If there's an instance where, for instance, there might be a witness for a federal trial that, they want to hold there, this won't interrupt that you can still have all those relationships that you've currently had.
Usually that falls with the U.S. Marshals. And they will lock up a witness. I've never experienced it with ICE, so this is specifically, when we talked about it last week, we were trying to wordsmith things, to try to get to where we are.
Yeah.
The elephant in the room is ICE and some of their tactics about asylum seekers. And, I've been trying to stay away from that and only hold the criminals, the worst of the worst. So this allows us to hold the worst of the worst. And the asylum seekers, ICE can still do their thing. And I had an agreement with ICE that I wouldn't hold them and they moved them to other places. So they're still going to do what they do. It's just that in Maine, jails won't be holding the administrative or civil violators that everyone is concerned about.
Will, just a question for you too. This is entirely permissive, right? That the statute doesn't prohibit this. It just says that it's not required.
This statute of itself, that's
The amendment to the statute.
yes, if we're just focusing on that part, yes.
Yeah. Okay. Thank you, Sheriff Joyce, for all of your efforts in trying to make sure this is as, narrowly tailored as it can possibly be and really is going to address the crux of what is attempted to be addressed here.
Okay.
Thank you, Mr. Chair. Will.
Mhm.
So is there any conflict between the highlighted section of 1971, including detaining a person solely on the basis of a hold request, and the language of the amendment on 2058?
So I don't think so, just because if the language was more specific in 2058, and this isn't necessarily just the language in terms of what's provided in the amendment, but what was already in the statute beforehand.
Right.
It is weird because there's no language in terms of like must not, or you're not allowed to do this. It is, there is that element of local control in there. It's just saying shall be available at times unless the persons are detained solely for this.
With unless being
the major term. So to me, in that bill specifically for 1971 as well, of that section in there saying that a law enforcement agency may not, so it's kind of weird because you have one statute that's saying you may not do this. And then you have this statute that's like, when it was originally written, wasn't as prescriptive in terms of you may not do this, it's what you shall do. It was different that I don't think they conflict. There's no conflict necessarily. I think there's a little bit of oddity in terms of how they're drafted. If we have this law saying you may not do this, and then we have this law that just says, well, you know, there is a level of local control, but it's not necessarily prohibitive, but this law still exists for 1971. So in effect, I think 1971 is going to rule in these situations in terms of what the actual outcome is. I think that this just helps kind of clarify it a little bit in terms of 1971 exists. Why does this exist in Title 25? It's a little bit of an odd situation, but
Yeah, I agree. Thanks, I guess.
yeah.
Well, when you say that, but to clarify, this amendment then sort of clarifies Title 25 to be read in conjunction with instead of in opposition to.
I think at least it's less conflicting with the new law that has been enacted. Because it says municipal and county jails should at all times be available except for in these situations, unless the persons are detained solely for a civil immigration violation. If you read this completely in a vacuum, it's telling you of when they shall be available. But unless in this situation, it's not saying shall be available, that's up to the county jail. So if you're just looking at that section in and of itself, yes, there is some element of local control there, but that's the point of me bringing forward 1971. And I'm not saying it's an issue necessarily. I'm just saying in 1971, this isn't the full picture, Title 25, this provision. It's, well, we have a law that goes more specifically into holding somebody for detaining a person solely on the basis of a hold request. And again, I mean, that language, there's definitions for hold request and immigration detainer in 1971. So, I mean, there might be some slight differences between, because that uses a civil immigration violation versus that one has basis of a hold request, but I think it's generally getting at the same idea. So again, I don't think it's conflicting necessarily. It's just that you shouldn't view that section, Title 25, in a vacuum, because I think it has interplay with Title 5, Section 4761, or Chapter 33, sorry, 337E.
Yeah, no, I hear what you're saying.
But there are those who might have a more sophisticated opinion or interpretation of that.
Yeah,
So,
I don't know. Senator Sewell?
Yeah, I just, I'm at the point where I can't vote for this to pass because I feel that we should have had federal agencies included, even US Marshals or someone. And I asked that during my testimony. And I even vented that I could not pass it if we didn't have all the stakeholders involved. And so that's where I'm at. I don't think that we've got the whole picture. And so we really need to have the whole picture to make a decision. And I'm not there. So I'm going to make a motion not to pass.
A second that.
Then if we take a real 5 minutes, and we'll come back and then we can vote on this. Okay, thank you.
Okay, LD 2058, the motion is ought not to pass by Senator Searway and seconded by Representative Ardell. Representative Hassenfuss.
No, I'm voting against the motion.
Representative Hassenfuss says no. Representative Nadine.
Yes.
Representative Nadine says yes. Senator Searway.
Yes.
Senator Searway says yes. Representative Lookner is absent and Representative Abdi is absent. Representative Perkins.
Aye.
Representative Perkins says aye. Representative McIntyre.
Yes.
Representative McIntyre says yes. Representative Ardell.
Yes, I am supportive of the motion.
Representative Ardell says yes. Representative Bunker.
No.
Representative Bunker says no. Representative LaJoy.
No.
Representative LaJoy says no. Representative Milliken.
No, thank you.
Representative Milliken says no, and Senator Curry is absent, and Senator Beebe Center is absent. So we have 5 in favor of the motion and 4 opposed and 4 absent.
Bernice, the report of all those members who are not in favor of the motion will be the amendment that we received on 316, generally as drafted with any language corrections that need to be made by our analyst.
So ought to pass as amended on the opposing report. Thank you.
Okay, so I was in fact wrong, and that was one of our speaker ones, so,
Got them all wrong.
you know, so shows how much, we should trust, yes, but luckily, there's, but I suppose that's a pleasant thing. So now, we will take up our final bill of the day, which is LD 2165, enact to change supervisory authority over the Capitol Police. And Will, I think if we could start this by having you walk us through the most recent amendment, and then walk us through what discrepancies there may be between interested parties and what language we need to address.
Just to
here.
clarify, by most recent amendment, public hearing, did you guys get a new one I didn't? Or do you mean?
No, I think it was the
Public
amendment at the
hearings.
public
Okay,
hearing,
yes,
so,
okay,
yeah.
okay.
I'm not aware of any newer
Yeah, okay,
amendments
just
that are
making sure.
circulated.
Okay, so we'll briefly just talk about the original bill. So the bill is printed, transfers supervision duties of the Chief of Bureau of Capitol Police within DPS to the Chief of State Police and replaces the position of the Chief of Bureau of Capitol Police with the Maine State Police Lieutenant. The bill provides rulemaking authority regarding security at the Capitol area to a designee of the Commissioner of Public Safety and requires that rules adopted governing security at the legislative offices and other offices within the Capitol complex include consultation with both Commissioner and the Chief of the State Police. The bill also requires that the Chief of the State Police replace a Capitol Police officer position that is vacated with a State Police officer position contingent upon the funding of the reclassification of that position. So we did receive 2 amendments at the public hearing, one from the Department of Public Safety and one from the Maine State Law Enforcement Association. So the DPS amendment made 2 changes to the original bill that was contained in section 4 of the bill. So the first change removes a reference regarding the Chief of State Police maintaining supervision and direction over any state police officer that was assigned to Capitol Police. As explained by DPS during the public hearing, the intent of this change is to make it clear that if a trooper is assigned to the Capitol Police and is working at the Capitol, that their immediate supervisor would be the commanding officer at the Capitol. So in this case, the Maine State Police Lieutenant, rather than going to the Chief of Police. So that I think that's just a clarification there that I believe was agreed on by both DPS and MSLEA. And there are the changes highlighted for you there at the top of page 2. And then the second change in the DPS amendment, which is also in section 4 of the bill, clarifies that a state police officer will only replace the position of a Capitol Police officer through attrition. That aligns with the header of the subsection, which did explicitly mention attrition, but the original language actually didn't make any mention of attrition in subsection 4. So that's now addressed. Again, I think that was okay with both parties. Of course, MSLA doesn't agree with in general, but I think they both agree that that was an appropriate change if you are in support of that idea. And again, the language is there highlighted where it differs from the original draft. And then you had the MSLEA amendment. So that retains sections 1 through 3 of the bill, which establishes a state lieutenant police position to supervise Capitol Police. Those technical changes we talked about earlier in terms of rulemaking and allowing the commissioner's appointee rather than just the commissioner. And then a section, again, regarding a commanding officer, which aligns with section 1. So I think that part, all pretty standard there. Their change, though, was largely removing a lot of section 4. It removes all the changes with the exception of assigning a state police officer to a command position in subsection 3 within the Bureau of Capitol Police, which would be consistent with section 1 of the bill. So generally, that amendment modifies just the command structure of the Capitol Police at the higher level, but otherwise maintains the Capitol Police's current structure. They did note during their testimony too that they would be content with making no changes to the Capitol Police, but that this was one alternative if the committee and the judiciary at large sought to make some change to the Capitol Police structure. Pursuant to a legislative request, there was some information requested of DPS regarding long-term fiscal impacts of the transition from Capitol Police officers to Maine State Police. A chart providing a more detailed breakdown on the salary differentials and equipment cost is attached to the next page. There was provided a preliminary fiscal impact statement on February 19th that said this would not require a fiscal note at this time. Obviously, down the road, they will have to come back for those reclassifications at a later date. And so that second page is the attachment. Thank you to the Department of Public Safety, Commissioner Sawchuk, for collecting these numbers for us to give you an idea of what those rates will look like in the future. The lieutenant change from Capitol Police Chief, if any member is interested in just that one position changing, seems like a fairly small difference. The difference there is $17,000 just for the one person. If we're looking at a complete structural change to the Capitol Police, from my understanding, that's the number you're looking at there, $516,258 for the salary. And then there will be other certain costs for equipment found at the bottom for the total overhaul restructure. That's all the information I have. I know there's a lot of conversation about labor disputes, pay disparity, promotions, how those would be addressed in statute. I'm not entirely sure, but that's up for the committee to decide.
Thank you, Will. Does the committee have any questions right now? Senator Seaway?
I was wondering if it might be more practical to make this a study so we know the figures, how it would operate, all that, for the next year to take a look at this, because to me, it's going to be kind of complex about how it all integrates later on. And I'd just like to see a picture of it, it just seems like we're kind of moving fast on this and just not really knowing how it's going to operate, because I hear from, state police, I hear from the other side, and I hear, they're worried about, I don't think they even know how it's going to be structured. And they're worried that, some state police could be called out during times when they should be securing the facility. They're worried about pay structure. They're worried about equal treatment. There's a lot of different ifs in this that are not really covered yet. And so I'd be more than willing to have a study done and then come back and see how it would work. That would be my thought.
Representative LaJoy?
I might get shot for this, but just thinking.
Well, I will say that if it's gonna happen in any committee, this is the committee where you probably want.
There's no paramedics in here right now.
Yeah.
You're not on a bad path, Senator. I'm looking at this, there's a new administrative leadership coming in next year, totally new, which may not or may go along with the changes that are proposed. We don't know that. That administration will be here for the next 4 years. I would almost suggest that we or the individual, the commissioner that put this forward, bring it back in the 133rd and deal with it with them, with the new administration. And we don't even know if they would accept this or not. So I guess that's my thought and my direction. I believe the commissioner has a good process by the way he's thinking to change things. Again, I'm still looking at the new administration, whomever that is, that will have to live with those changes for the times that they're here. So that's my spiel.
Thank you. And Representative Perkins?
Thank you, Mr. Chairman. I agree with Representative LaJoy. I don't think we need a study, but I do agree that we do have a new administration coming in. And I personally have some concerns about the cost. I know in the public hearing, we heard a figure of 1.7. Now we're looking at a figure of almost 1.2, most of which is vehicles. And I think that because it won't be long before we have the new administration coming in, I don't think it would be a bad thing to hold off on this for a short period of time. And so therefore, I'd like to make a motion of ought not to pass.
There's a motion and a second. Will, I'd like to kind of walk us through the bill a little bit, the actual language of the bill. And where there's an amendment, stop me a little bit, but it seems like in the bill, section 1, basically taking the police chief, transitioning to a state police lieutenant position, that there's no amendment to, that was something that everybody sort of bought into. Is that your understanding?
By what everybody bought into, I mean, so like I said, from MSLEA's amendment, they did retain that part saying if you are going to go forward with something, address the leadership, not the entire Capitol Police. But it is also their position that you could also just find a new chief of Capitol Police as well. You don't necessarily need to go through with that either. So that was one alternative. So by everybody was okay with it. I mean, it's a
one of the major sticking points. So there's that piece there. And then when we get to section 3, we're basically just kind of doing language changes for.
Yeah, I would say section 1 through 3 is there's not much of interest there. Really everything in here is contained in section 4 of the bill. And so to that point, section 4 is what folds in the state police officers into the Capitol Police. So that's where the MSLEA makes a lot of these changes. If you see all these continued changes regarding state police officers throughout the bill, that's because they would be, taking over through attrition in that part. So that's why MSLEA was taking out those portions of section 4. And then section 3 and 4, subsection 3 and 4 within that obviously is the bulk of the language that we're working with here that actually has like most of the operative effects. So to that point, section 4, I believe, or subsection 4 was completely removed by MSLEA because that's regarding replacing those officers through attrition, which was not part of their amendment or not what they're looking for.
Yeah, so essentially going through, page 1 and then all the way up until page 3 of the original bill, that's all pretty boilerplate-ish.
Yeah.
And then the real crux that we're looking at is 3-4. To which there's been a few moving amendments through there. So I think that's probably where we should focus our attention. Representative Bunker?
Thank you, Mr. Chair. I have a couple of questions for the commissioner, if I can have you come up.
Yeah, you certainly can.
Play some devil's advocate with you, Commissioner. Tell me about, and I am not an HR specialist, but tell me about the challenges of this transition with HR and collective bargaining and rate changes and things of that nature. How immense or modest is that challenge if we were to start now going forward? Big deal, small deal, somewhere in between?
Yeah, so Mike Soster, Commissioner for the Department of Public Safety. Good to see everybody. Thanks for having me at the end of the day here. I would say that at the end of the day here, we're talking about a sworn complement for the Capitol Police of 16 and a half officers. Right. So in a worst case scenario, if you wanted to whiteboard a massive problem for 16 people, which this is not, that would still be pretty easy for us to manage. As a chief of an agency of 225 and 163 police officers at one time, as a commissioner of an agency with 700 now that has the Maine State Police with 352 sworn, the logistics around managing change for 16 officers is not, it's like a regular Tuesday for us. I don't think that's a problem at all. I think the situation here is that we started with a bill that was as simple as humanly possible. That bill just said, we're going to change Capitol Police Chief to Colonel, and that's all we're going to do. And then after that, what we heard in the media and elsewhere is that they're going to fire everybody. They're going to fire everybody. They're going to fire everybody. Never said we were going to fire anybody. Nobody's ever heard me say that's not going to happen. So we added attrition, this replacement concept through attrition into this bill. So that's where that 3-4 starts to come in, where there are changes there. So the idea here is that a Capitol Police officer leaves for whatever reason. They could retire, they could resign, they could go, whatever that is. When they leave, that we would reclass that position to a Maine State Trooper and hire for a Maine State Trooper, or in many cases, transfer in if somebody wants to go, or hire if it's an absolute vacancy and there's nobody that's willing to go there. That's going to happen repeatedly over time. And when we talk about the finances here, there was a lot of conversation in a public hearing and work sessions in the past about how long is this going to take? So if you take that $1.1 million and you put that over 20 years, we may get 3 people that leave 1 year. The next year we may have none. So the reason that this has 0 fiscal note at this point is because we don't need any fiscal note from this body at this time. And when we do, a next body is going to have to look at reclasses. The HRs have to look at reclasses, and then this body will have to vote on that. I don't look at this as some huge insurmountable HR nightmare. I just don't.
A follow-up, Jimmy. In reference to the comments about new administration coming in after elections and something of that nature, the pros and cons of pushing this decision off to another time versus making progressive changes now. What's the pros and cons of either?
So my concerns here are that when we're asking for new positions, whether it's EPU and these other things, the baseline is there 180% increase in threats in the last 4 years. Threats against legislators, threats against staff, threats against this complex. That's not going away. If the idea here is that we're going to push pause and we'll wait until the next administration comes in to make a decision, then we're doing that with existing resources under the absolutely exactly. We're going to literally push pause. We're not going to do anything else until then. I have to say that when the governor looked at this bill and the Senate president and the speaker looked at it as a priority, I don't think anybody looks as a commissioner role as a lame duck scenario. Like, I got to stop initiating new things a year out from when this administration leaves. That's not the idea. I have problems that I need to address. So that's what I do. People pay me to make decisions. I make decisions. You may not like it. You may vote against it. But on my end, it's the only thing that makes sense to me is to move this organization forward in a positive manner from my perspective and do it now. Because I came in, as an example, 7+ years ago in December. So let's wait. There's an election. There's a new commissioner. The new commissioner's got to come in and get his feet wet or her feet wet and figure out what we're doing and who's doing what to who. And then we figure it out from there. And then you make any changes that you may need. So we're going to add a year to this thing at a minimum before there are any changes to that. And that just doesn't make any sense to me from an operational standpoint. I'm the operational guy that's going to take this and move it over here. There's a lot of operational folks in here that have a lot of experience doing stuff. And from my perspective, this makes the most sense for me as a law enforcement leader and the commissioner for the Department of Public Safety right now in 2026.
That's all I have. Thank you.
Representative Perkins.
So, Commissioner, thank you for being here. So you mentioned the increase in threats as part of the reason for moving this forward, but you're not adding any positions. You're only replacing, and you're not going to be definitely not replacing necessarily any of these positions immediately. Is that correct?
Yeah,
You're
that's
still going
correct.
for the same complement.
The same complement, but what we are offering when we talk about operational efficiency, crisis response, technology, all of those things, you're plugging an agency of 16 people, 16 police officers into an agency of 352, twice plus any other law enforcement agency in the state. All of the resources that they have available to include changes to dispatch, changes to records management, changes to availability to tactical teams, changes to a command structure. All of those things are going to better this agency. Whether we said, oh, it's 16.5, but I'm going to add 10, that's not what we're doing here. But the operational efficiencies, the resource management, the resource allocation that's available to that department is exponential in comparison to where they are now.
So I've been here on a weekend when there have been activities going outside, large groups of people, and there have been a large complement of troopers here supplementing the complement of Capitol Police. So are you saying that right now, as things stands, there are resources at your disposal as commissioner or from the state police that aren't available to Capitol Police should they request them?
So Capitol Police would submit a threat matrix or threat assessment like anybody else. And they'd say, this is the crowd that we have. And they would say that we think we need assistance from crowd management. And then the Maine State Police would make a determination whether or not that fits their mission, that criteria. And I think with your experience, you know the difference between an agency, we have a mutual aid agreement, or you're actually the same agency. You're actually the same agency with the same command structure and the same mindset, the same policies. All of those things make that a lot easier to work through every day of the week.
I think there's a little bit difference between Bangor calling on Brewer and one part of DPS calling on another part of DPS. So
those are standalone law enforcement agencies, just like anybody else. I can come in and mandate whatever I want from a DPS perspective. That's not the way the world works. That's not the way I work. The Maine State Police have policies, they have procedures, they have threat matrices that I don't expect that they're just going to throw out the window because I hold them accountable for budgets. I hold them accountable for these things. So if we push pause at this point, so what I'm going to ask is the Maine State Police pick up additional liability, responsibility, and we're not going to change anything else. So you guys just take that on for me, but we're not going to change anything at all. And I think that's an inappropriate ask.
I guess I'm not feeling it. So if Capitol Police calls and says, hey, we need support from Maine State Police, whether it's an external calling for mutual aid or as part of the same agency, you're saying there's going to be a difference in the amount of support they're going to get.
I'm saying that if it's within that same agency, your threat matrix and all those other things may be different, right? You're literally calling another member of the Maine State Police to say, hey, we need this. We need access to the crime lab or something else. And you know how organizations work. So if the policies are different, the budgets are different, the priorities are different, and that's okay. That's what agencies do. The fire marshal's office is not the same as Capitol Police, which is not the same as the Maine Criminal Justice Academy. Everybody has their own budgets. Everybody has their own struggles with staffing. Everybody has issues with recruitment and retention. So it's not just everybody's in the pool with DPS and you get whatever you want. Still people, they're going to cooperate. They have a good relationship now. Can it be better? Of course it can be better. It can be better if it's under the same umbrella, the same organization.
Okay.
Senator Seaway?
Yeah, I just, like I said, I still think that there's probably a lot to this because, I mean, we'll just say the museum too. You got, maybe need security there. Maybe you need security in other state areas that own buildings. I don't know, but I'm just saying that it seems like, you know, you have a state lieutenant, state police lieutenant. He has the ability to go out and get the help that he needs through the state. If we keep as is right now, until we can figure this out and maybe, you know, come up with more, because the cost is quite a bit. It's going to be quite a substantial difference, you know, eventually. And then you got, the structure of wondering if they're going to be called out. You know, if you said, well, I need you, we're going to have to take you out of this facility to do something else. I don't know if that happens or not, but that's where we're kind of like stuck. We're saying, and this is where I'm getting a lot of information, misinformation it might be, but I don't know. We really haven't heard that piece. What happens there?
Well, from an operational standpoint, I'm happy to get in the weeds if this committee wants to talk about exactly how this is going to look in a 24/7, 365 operation.
Yeah.
And no, I wouldn't expect that a trooper that's assigned here to Capitol Police is going to get pulled off a post at the kiosk downstairs to go someplace else to deal with another emergency outside of any other response that somebody could have now. But you do talk about training. You do talk about the priorities that they have now, and whether it's hiring or the 8-week extra RTT. So if you have a trooper that's assigned to Capitol Police, they would have the capability to go someplace else. They would have the capability to go deal with another emergency outside of an existing shift. They have a responsibility here, and they would ultimately look like a Capitol Police troop. So we're not pulling people off that have a responsibility of keeping you safe.
Yeah.
The cultural building, we've already addressed those things. I've got security assessments all over the place. If you'd like to see those, and there's nothing here for us to study about where this is going to go. I don't have any questions about how this is going to play out. I can understand it if you do, but I don't have those same questions. And I think MSLEA, truth be told, this process with impact bargaining and beyond has been helpful. One thing that I heard at the end of this last conversation in the work session was a conversation about supervision, that sergeants and promotion and detectives. And from that, we went back and said, that's a really valid point, and we should look at that. Representative Ardell, I put it right on there, quotes. And so in that scenario, I thought that made sense. And we shouldn't try to top them out and not give them any additional opportunities. So we went back and drafted something up to say, so the first time that a sergeant leaves or the first time a detective leaves, we want to open that up to Capitol Police officers to have the first bite at the apple. If we have a viable candidate that's in that agency right now, then you would promote them to those positions. Now, that goes counter to a bunch of other folks that are worried about the length of transition. But I thought it was a legitimate point. I thought it was something that we could bring to the table as a concession to try to do additional things. We're not just offering Capitol Police officers additional specialties, as an example, that they don't have now, giving them additional resources to make them safer, make them easier to accomplish their mission, and make all of you safer. That's not all we're doing. We're also trying to make sure that they have some of those opportunities in place. So we drafted a change to that. But to my understanding, and Director Anderson would be in a better spot to say that, they voted it down 8-1 and weren't interested in that particular change, probably in comparison to something else, right? They would prefer to keep just a lieutenant and leave everything else the way it is, which again is problematic for me.
Senator McIntyre.
Thank you, Mr. Chair. please expound on why it's problematic. I'd like to know. Because if you have an LT there, by proxy, that puts the uniforms under the umbrella you're referring to. So you indicate problematic. Can you explain a little bit more why you see it that way?
I think that there still or will be, continue to be two different contracts. So just because there's a Maine State Police lieutenant there, doesn't mean that these are troopers with the same policies, the same hiring, the same training, the same equipment, the same dispatch system, the same records management system. All of those things are currently different. So if all of those things are different, then you just have a warm body over there that's in this case, acting as the chief. But all of those things remain different. That's not progress. That's not moving the agency forward. That's still having two sets of policies. So a Maine State Police lieutenant who's been a lieutenant for 25 years now has a different set of policies with the Capitol Police. Their equipment is different. They're using a completely different records management system. The only state law enforcement agency with a different records management system. So that's completely different from where they're currently at. Their dispatch center is a building control dispatch where they're dispatching a plumber 1 second and they're doing a police officer the next. That's the only state law enforcement agency that has that in place. I can move those things forward in a more expeditious manner if they all fall under the same umbrella with the Maine State Police. That's the things that I think are problematic.
I don't see any further questions, so I'm going to go back to the language a little bit in the bill. So I see paragraph 3, I see as sort of the commissioner may giving the ability to assign state police to Capitol Police. So one thing you would need to do is essentially say, okay, as Capitol Police officers retire, we have to then have the ability to have some state police go in, fill that role. I get that. I understand why that would be needed, or language similar to that would be needed. Right, Commissioner and Will both like, we would need something in there authorizing the state police to have state police officers under the umbrella of Capitol Police via statute. Right? Yeah. Okay, so what that would look like, we could debate, but we would need some sort of paragraph 3. And I think paragraph 4, Commissioner, as you mentioned, was sort of your attempt to try to say, look, we'll make the promise to everybody that we're going to do this through attrition, and that when somebody retires, somebody else will come in from the state police. The shall language, I think, is really important there, because under the original language of the bill, it says that this has to happen subject to what DAFS is going to do. Commissioner, do you take the position that we would have to legislate that this is a requirement, or could we leave that open-ended?
I think all operational issues should not be legislatively mandated, to be quite honest with you. So if that's your question, then I would say no. If the question specifically is the shall, I think the capability here of that shall would push folks to the location of a reclass on each one of these. And now, if for whatever reason, from a funding perspective, we're not allowed to do that, we do believe we have the capability to backfill those as necessary. So whether that is a Maine State Trooper that's coming off the road someplace else, or absolute worst case scenario is some kind of a Capitol Police hiring after the fact.
And the reclass, so I'm sure, I don't want to get too much into the weeds of that, but if this were to go in place, would it be easier to get a reclass where Capitol Police officers could get a bump in pay? Do you think? I don't want to get too in the weeds on negotiations, but is that how it works generally?
I would say that from my perspective, whenever the next negotiation cycle comes up, if MSLEA wants to make this a priority, I'm sure they could put a package together that say, we said this, and this is what we've observed over the last 8 months, 9 months, that leads us to believe that these positions should have more pay parity. I would say that all of these positions, the Maine State Police as well as the Capitol Police positions, were all reclassed just last year. Those are not decisions that we make where those land. That is staffs, the mothership, big HR, looking at positions and what they do and determining what those salaries are.
Are there any other questions for the commissioner? Commissioner, before I let you go, though, I do want to ask you, what do you see globally as the real advantage? Because obviously, you know, there must be an advantage here, and I ask that to you or the major or whoever can answer it. But like, what is the real significant long-term advantage of having the state police take sort of merge in with and then completely take over the Capitol Police? And I know you mentioned some, but you know, I'm sort of giving you the floor to articulate, you know, as to what the real public safety advantage is.
Sure. I think that when we talk about resource allocation, operational efficiency, and crisis response, we are plugging an agency of 16 individuals into an agency of 352. At a baseline with zero law enforcement experience of any kind, I would think people would be able to look at that. Its size and scope is not always a good thing, but in this particular case, with all the capabilities that the Maine State Police bring to bear, plugging that agency of 16, which has traditionally had a hard time recruiting officers, certainly newer officers, newer blood on the beginning of their career. We got some amazing retirees, like they're really, really, really good people across the board at the agency. We truly do. But I think if you're plugging that in to a larger machine, they've had a hard time buying cruisers at times in the past. They've had in the previous chief timeline getting old equipment from the Maine State Police and passing that down because the budget is completely different. The capabilities are completely different than the Maine State Police. That's going to be your primary driver here. And I can give you a 20-page report of what the Maine State Police provide on behalf of the entire state of Maine. And this agency is now getting tucked into that. So I think there's an immense number of benefits with doing that. And I do think that additional training is going to come into play. There's a different equipment package that comes into play. And all of those other things are right there at our fingertips with this in mind, this transition in mind. And the idea here is that I'm trying to respect the amazing officers that we have now while thinking of the future. And this is 2026. We've got to start moving in a direction that acknowledges the fact that threats aren't going to go down. This isn't going to become an easier gig by any stretch of the imagination. I'm concerned about your safety. I'm concerned about the officer's safety and anybody that visits this complex. I think plugging them into this bigger machine makes a lot of sense, or I wouldn't have made that recommendation to begin with.
Senator Seaway.
So how many cruisers does the Capitol Police have currently?
In their entire inventory, I don't know the answer to that.
And so with these troopers that come here, would they have a cruiser that they take home and whatever? Is that would that?
So I think what Will had said is that there is a little diagram that's on the back here, which I believe is included in your stuff. One of the benefits of coming back again is that we had an opportunity to dig in to the finances here. And I gave you a loose number to say, it's about $100,000 more for a trooper over a Capitol Police officer. 54,000 of that is vehicles. But when you look at this, it's really closer to that 116 number because the Capitol Police already have 4 take-home cars as it is. So we don't have to repurchase those. They have lines for equipment already. The Maine State Police have additional equipment that does come with that. So automatically, my guesstimate of 1.7 comes down to, let's just say 1.2. So if the specific question, sir, is around take-home cars, the other troopers would have take-home cars, the ones that don't already have those positions and vehicles already accounted for.
Yeah.
Representative McIntyre.
Thank you, Mr. Chair. Commissioner, in regards to the 180% uptick in threats that are being reported, is there anything that the Capitol Police is not doing to address those in comparison to what state police would offer? Give me an alpha bravo of what you think what deficiencies might exist in the current structure.
So I think the size and scope of the issues, we currently have one detective at the Capitol Police. I'll give you an example. So he does spend some time at the Fusion Center, which is an entity that's solely the Maine State Police. The Major Crimes Unit for the Maine State Police handle every investigation under the sun, from homicides all the way down. So to talk about the expertise and the ability to snap in and assist as necessary, if we get too many of those threats that end up needing an additional investigation, then we can immediately go Maine State Police to Maine State Police with the same policies, procedures, and everything else to do those additional investigations. So I think we've got some good people. We don't have enough of them. There's no doubt about that. And that one detective that we have does an amazing job, but he's one person. So I do think we can use some of those existing resources with the Maine State Police to assist with those investigations as necessary.
Thank you.
Sure.
If there's no further questions for the commissioner, I think we can let you off the hot seat.
Yeah, thanks. I'm not far away, so happy to jump back up. I like being warm.
I think, are there any other questions for any of the audience members? I would like to allow Director Anderson to come up and are you hiding behind Will there?
No.
And I had a, you know,
Can hardly stand up.
quick,
They get the blood flow going.
quick question before you. So, I mean, I certainly understand your members there. Through this amendment, is it just a complete aversion to having the state police assume this role in the future, or is it things that you anticipate could be worked out, but just sort of need more time and more discussion and things like that, stuff that the legislature necessarily can't really do for you, not do for you, but like just not,
I
yeah.
think it's a combination of both. I think realistically, I think there are some avenues you could go with this. I think there are some things you could do to enhance operational efficiency and information sharing. There always is. I don't think this is the answer. Having the state police lieutenant there, that's why we put that amendment through. It wasn't our ideal, but it does kind of address that a little bit. But to completely replace these guys that are doing the work they're doing, which is great, with the troopers, like I mentioned before, it's just all those moving pieces, the 3 different contracts, because you have the trooper contract, supervisor's contract, and then the MSLEA contract. So it's not just 1 or 2, it's 3. There's 2 different uniforms, there's different pay scales, and that may not be a problem the first time. But when you have somebody making 15, 16, 17 more dollars an hour, doing the same thing you're doing a year later, and now you're equal split, what happens when you get, say there's 8 Capitol Police officers, you have 4 troopers, 4 Capitol Police officers. 1 may not be a big deal, but then you have 4 and 4. What happens with vacation? And how do they decide which contract applies? What happens with overtime details? What happens with all these things that would need to be addressed and discussed moving forward? Things that I've thought of that aren't in these amendments, but why couldn't you just do a state police lieutenant and mirror a liaison with Capitol and have a state police sergeant and a state police detective to mirror and work with to solve the interoperability? I think all those things, and I think it's brought up here, that were accessible to these folks. It's all the Department of Public Safety. Like you mentioned, the fire marshal's office, the same thing. They fall under that umbrella. So it seems to me like you could share those resources and you could adapt the Capitol Police policies to be more similar to the state police policy if that was an issue. You could do other things to enhance operations. You could give another detective position. And can I address that just real quick on the stats side of it? I talked to the detective, and that detective position was created back in 2023 and wasn't filled until 2024. before that position was created, there was no conduit for threat assessments and complaints in general, and no way to record them. When they hired the new detective, he came in February of 2024. If you look at the stats, it goes from whatever the numbers are, I think it's teens or 20s, all the way up to 50 something in 2024, which was reflective of a conduit now documenting all of these these threats against the legislature, the complex, whatever it may be. Then you look at 2025, which is the first full year that detective is now in that role. Before, there was no detective. It didn't exist. So now you have somebody documenting in a conduit to actually document all of those things. So it may look like, and I'm not saying these threats haven't increased, they could have, but I'm saying now you have an active person in that role, which is why the prior chief got that position to address those issues. And Pete is a very experienced detective and does a great job with it. As a matter of fact, now I think they've even advanced that on to a process even further, to an LTR. So you have some consistent way of documenting those threats. So I think there's other ways to accomplish this.
Are there any other questions for anybody? I think everybody, I see a deep breath there. Let's take 5 to 7 to 10 minutes and then come back in the room. Yeah. I heard that 15. Okay, we won't be any later than Thank you. And Will, when we left, I left you with a question, sort of, what do we really need to do legislatively through our language to authorize, the lieutenant to potentially be there and state police officers to be able to fill in on a permanent or part-time basis there? And do you have any enlightenment for us?
My interpretation would be, I think you need section 2, because that specifically refers to the Bureau of Capitol Police being under the direction of the chief of the Bureau of Capitol Police. So if that's being changed to a lieutenant, then I think section 2 would be required. Section 4, in my mind, I don't really see, if the intention is not including subsection 3 and 4 there, if we're just looking for the bare minimum of the legislature is not getting in the way in terms of language of them proceeding, however the administration ends up working things out, then to me, section 4 starts to become meaningless, because section 3 and 4 is the big language there. That is those kind of like guarantees from the commissioner about that this would go through the process of attrition, and a lot of the other references that in there into state police officers, to me, is just updated because of those additions from 3 and 4. So to me, if you're removing those sections, I don't think you would need section 4 at all, really, since those are the core of that. Section 3 itself, I mean, that's kind of its own side thing. I don't think that's necessarily related to the state police officers taking over control of that. That's just adding that designee language, unless I'm misunderstanding something there. So to me, I think section 2 is the major operative section in terms of what's the statutory language getting in the way of them accomplishing that. And I'm not sure on section 1. I mean, that's just establishing the position, which, I mean.
All right. Yeah. Well, thank you. And after we vote, we can go through this a little bit more so I can articulate my report. But I think there's a motion on the floor with a second.
Yeah.
Are there any other questions for any of the audience members by anybody in here? Okay. I don't see any other questions, so I think we're ready to vote. Bernice.
Okay, for LD 2165, the motion is ought not to pass by Representative Perkins, seconded by Senator Searway. Representative Hassenfuss.
No, I'm voting against the ought not to pass motion.
Representative Hassenfuss votes no. Representative Nutting.
Yes.
Representative Nutting votes yes. Senator Searway.
Yes.
Senator Searway votes yes. Representative Lookner, Abdi, and Perkins are all absent. Representative McIntyre.
Yes.
Representative McIntyre votes yes. Representative Vardell.
Aye.
Representative Vardell votes aye. Representative Bunker.
Forgive me, I've now confused myself. The motion is.
Ought not to pass.
No.
Representative Bunker votes no. Representative LaJoy.
Yes.
Representative LaJoy votes yes. Representative Milliken.
Yes.
Representative Milliken votes yes. Senator Curry is absent and Senator Beebe Center is absent. So we have 6 supporting the ought not to pass motion, 2 opposed, and 5 absent. And those opposing the motion?
So, I'll have to walk through this with you for a minute, but I know that I want to give the commissioner the authority to either hire a chief of Capitol Police or have a lieutenant of the state police be the chief, for lack of a better appropriate term there, and to run the
Supervisor of the Capitol
the
Police.
supervisor of the Capitol Police. Yeah, so that is at the discretion of the commissioner. The commissioner may appoint either or. And then I believe if that's the case, current law would already allow the the lieutenant to station troopers as, you know, in this, as Capitol Police officers if need be. But is that, are you aware of any other, I guess, and then also make any other statutory changes that would require the lieutenant to be able to sort of move state police in as necessary as officers, which I don't think anything is needed. If you just have the
Yeah.
lieutenant be in charge, I think it sort of flows from that, but
That is my understanding, at least right now.
yeah, but if there's any question on that, I guess just get back to me
Yeah.
with language, because my intent is so that the commissioner has the ability to have the state police lieutenant be in charge of Capitol Police, and if a number, you know, of Capitol Police officers retire, that they could fill that role with some state police as needed, knowing that if there's any new hires, it would obviously have to come back to the legislature for approval of any head counts, so to speak.
And it's not requiring that these be replaced with state troopers. It's at the discretion.
No, it's being essentially trying to be silent if not getting in the way of it, if that is what the trajectory is, but also not requiring it either. And I think that would allow the bridge between, because I know some individuals have said, you know, expressed that, well, we're in between administrations, but that would allow the bridge to set up a certain structure, see how that structure is going, have the ability to start implementing that, of course, with the legislature's approval, this committee's approval through reclasses, and then perhaps if statutory changes need to be made to help to implement that, then that would have to be through another bill next year. But
Yeah.
as we all know, legislators can submit bills and the governor can submit bills. So that's the intent behind the amendment. We might have to,
Yeah, that's good enough for me for now.
Yeah.
To get started and
yeah. And you're welcome to work with, you know, commissioner and figure out how that language best needs to go there.
Yep.
So your opposing report is,
Ought to pass.
Ought to pass as amended.
and Representative Bunker, are you?
LaJoy.
Representative,
LaJoy was,
Oh, shoot.
yeah, it was
I'm
not.
s-
no, I think it was, didn't Bunker vote against the motion and LaJoy voted for it?
No, you voted, I'm sorry.
Oh, you're right. You're right. Representative Bunker was the one who was voted against the ought not to pass.
So are you with Representative Hassenfeld, or you can, was that a mistake?
Yeah,
How
the
did you
original,
mean to vote?
Yeah.
The motion was ought not to pass.
I'm opposed.
Okay.
Yes, no.
so are you joining Representative Hassenfuss's motion?
Where it's basically saying that the commissioner can appoint a chief or a lieutenant.
Yes, I will.
So Representative Bunker, Representative Hassenfuss are ought to pass as amended.
Yeah.
And you, Representative LaJoy, were with the motion of ought not to pass.
Yeah, okay.
Thank you.
I think we're done.
Yeah.
Are we done?
We have some language review.
I have
Well,
language review if you want to do it.
what I would recommend for language review, probably from here forward,
Yeah.
is if you can just provide copies for us. We can all just come to our desk, grab them. If we have any issues, let you know within, I guess right now, within 24 hours. After that, it might be like, you know, ASAP, but I think that's fair.
Yeah, we can figure out the terms because I want to email as well so that everybody's aware of the parameters for language review. So is that how you prefer to handle the current stack right now? Is just, I'll put that on everybody's desk. You can come review it and then we'll do that going
Yeah.
forward.
Yeah, I think that works. I mean, I'd like to see a hard copy and then review it and then just can confirm via email. But I think if everybody can communicate with Will how they need to approve the language reviews, knowing that no response is an affirmative response.
And I will put those folders out tomorrow after I clean up the horseshoe. I have them on the filing cabinet, and then you can, if you choose to put them in your folder and take it home or whatever, you can.
You to sign it.
Yes.
Okay.
You have
All right.
3.
Okay, all right. Yeah, Will, is that's everything? That takes care of everything? All right, we're good, and I'm not aware that we're meeting. The speaker asked that we try to finish up this week, and so I think this is the last day unless you hear further from us, but don't expect it.
So the last 2 bills we just were referred, what will happen?
One of them has not yet been referred. The other one, I think, is just, I'll withdraw it. I think it's too heavy to be able to, really get, so the one that was referred to us that we weren't able to schedule for a public hearing was a bill out of the report. That was something that I kind of wanted to do, of asking I don't know the right term for it, but asking like the Department of Corrections and the jails and the county commissioners to sort of revisit the old review from the 90s of how can we really maximize efficiencies, mergers, things like that within the jail. And I don't feel like we would be able to really give it its proper due in the short time that we have. And so I told the speaker that I was fine sponsoring a bill next year, or having somebody sponsor a bill next year to really, and working on it in the off session to really try to get a good bill instead of something that was just rushed, because I don't see that we can actually do anything productive with that bill in the near time. So, but
What about the oral?
so.
Okay.
Anyways.
I'm adjourned.
Yeah.
You do whatever you want.
All right.
Happy birthday, Representative.
Thank you. It's been a pleasure spending my day with all of you.
And there will still be cake here tomorrow.
Get all my snacks.
What?